Everyone, you all ready to see what the defense has for this afternoon? I hope y'all did some self care. Angel Baby is asking, why didn't the defense call in Brian? Because it's not going to go well for Sarah. They don't want to call Brian. Brian would get put under cross examination, and it would come out that Sarah used to attack Brian. Is not what the defense wants the jury to hear. Hey, Al Lozareth. Hi, C Perk. Are you guys talking about Napoleonic law? Very interesting. I got a smart crew here. Jay Borrego says, based on the neighbors, she knocked him out because they were yelling and screaming, and then it was dead silence. And then he heard something going down the stairs. That is exactly what I think. Hi, Leah. Can Brian be called in during the prosecution or rebuttal? Yes. I cannot. I think he wasn't completely released. I think he was subject to recall still. So hopefully that's the case. I can't remember now. Leah's asking, what did you think of the video of him smashing the television? A lot of people commented and said that it looked like a game. Like it didn't look like it was some big scary thing. Thank you, Kathy, for your comments. Elle is saying, yeah, Brian's subject to recall. Okay, I thought so. Sorry, I just told somebody who was texting me that I can't text because I'm going on live and they're texting me anyway. So I'm not going to respond to that. Leah thinks the TV was broken and they had to take it out to the trash. Oh, yeah. I wanted to mention something. Somebody told me in the comments, actually, a couple of people did, that there is a book on DV, and the title of the book is called Terrifying Love. And Sarah was careful to use those exact words in her address to the jury. And I am hoping like heck if Mr. J doesn't already know about that book, I hope somebody tells him about the book. I think that is really important. I think the jury, knowing that, might see her statement in a different way. Nancy's saying, I wonder if he had the bat, came out of the bathroom and knocked him out. Yeah, maybe. Who knows, right? Elle says she's a straight eight student, so of course she's been studying. I'm going to just check the stream. Okay, nothing's happening yet. Criminal Minds is saying it reminded her of the video of Amber Heard took of Johnny smashing up the kitchen cabinets. Oh, Cat Wrangler says, I wonder if that book is in the jail library. Interesting. We say howdy here is saying hopefully they are watching, meaning the prosecution. I am 100% sure that they are not. They have a lot to do. And those poor guys need a break sometimes. They've been working outside of regular business hours a lot. A Silver is saying there's been several passive aggressive digs at Brian from her. Yeah, yep. She has to just slide that in. Have you ever known? I think a lot of us have known people like that. I find, for me anyway, passive aggressive stuff gets really gets on my nerves. I have no patience for it. And I know I handle it completely incorrectly because you're not really supposed to confront the person, but I do. I just say, yeah, what do you mean? Come on, spit it out. I don't handle that well. Kimberly is saying, how many people do you know and trust enough that you would allow them to zip you up in a suitcase? Kimberly, that is if she indeed zipped him up and he allowed that. I don't believe for 1 second that they were playing hide and seek. I do not believe for 1 second that he got into that suitcase voluntarily. Not, I don't believe that at all. It's just that Sarah's narrative has been repeated and repeated and repeated so many times that people stop really thinking critically about that. And it has become accepted as fact. And I'm convinced, 100% convinced, it is not a fact that he did not get in there willingly. I know people disagree with me, but you're using the narrative of a liar as a premise for a theory or a foundation from which everything else flows, and it's bound to be flawed. That's my opinion. Megan is pointing out another thing about the TV video. George was hitting the TV, not Sarah, not even Sarah's direction. Uh, was very controlled in his hitting of it. Her hand wasn't shaking in fear while she's videoing, right? He was so out of breath and weak that he could barely beat up the TV. So I think that says something too. And she claims that she had a 200-pound dresser that she barricaded the door with. Wiley Coyote Super Genius says, I think she thought Brian would help her and she planned to leave him in the suitcase. I think that's plausible. Oh yeah. Marco is saying she asked if Owens wanted her to demonstrate how she hit him with the bat while he was in the suitcase. And cold. Yeah. Yeah. Because if you did something to somebody, even a stranger, in self defense that caused their demise, you wouldn't want anything to do with it. You wouldn't want to be near the suitcase. You wouldn't want to demonstrate and relive that. I think her pictures and videos of the suitcase, I think they're her version of trophies. And I think she's enjoying reliving. She's not horrified at all. Loba is saying Brandon and Brian are coming back. Just checking the stream. We got nothing yet. Okay. Barnabas Collins says Dr. Brennan listed all of Sarah's diagnoses. Yeah. Moth's mummy is asking, did she want Brian to drop the suitcase in the river? There is a pond that she mentioned out back that she liked to walk around. And You gotta wonder. And somebody claimed, I think it was in the comments, that they inputted her latitude and longitude on her phone records, and they think that she late at night had taken a walk around that pond. So, was she scoping it out? I don't know. I don't know. Whatever she thought, it wasn't very well planned, obviously. Yes. NRH is pointing out something that says, oh, hello, Dr. Barry. NRH is talking about Owen's argument, saying that, well, George consented to getting in the suitcase. And I talked about this in one of my early videos on this case. Consent can be revoked. Consent is a dynamic thing. It has to be ongoing. And the second that he withdrew his consent and she failed to honor that second she is committing a crime. So even if he consented, the second he said, no, I want out, that was it. And you think of SA cases, for example, right? No is no, and you can revoke your consent. Or you can consent only to certain portions of something. So if the tables were turned, if it was a man who locked the woman in the suitcase and beat her with a bat and laughed at her and called her names, would we be having such a discussion? Right? I think people don't extend the grace to male victims as much as they do female ones. Robert Greene says no means no. Yeah. I would argue that anything other than an emphatic yes means no. If it's not yes, it's no. HRH Mom, I'm so glad Brian didn't go inside that apartment. Oh, yeah. Could you imagine the complications that could have come from that? Oh, boy. That was a smart move on his behalf. On his part. Sadie says, I really think the suitcase started upstairs. Yep. I think a lot of people think that. CB is saying, yeah, if the situation were reversed, it would be very different. Barnabas is saying, you're the same way as me with passive-aggressive people. Yeah. And I'm sure that if a psychologist or a therapist saw the way I responded to that, they would tell me, oh, that's not the way you do it. But I don't care. I was just so irritated by that. Dr. Barry says, I think Sarah would have blamed Brian. I agree. She will throw anybody under the bus as long as it's not her. Everybody's terrible except for her, right? And that was hilarious when when the prosecution was asking the expert about narcissistic traits. That was gold, man. Elle says she blames him for being dead and putting her in this situation. That I've seen that. I have seen that before. So is that a possibility? Yep. Oh, Veronica, don't even get me started on the judgment and misogyny of Detective Copsall. She wasn't being a mean girl. Oh, yeah. She was interrogating a murder suspect. Thank you. I have been called a bee, ice queen. Been called every nasty name under the sun for doing exactly the same thing at work that a man would do. Here we go.
All right, we're back on the record. Case number 2020 CF 2603, State of Florida versus Sarah Boone. Let me get appearances for the state.
Steve Chester on behalf of the state. William Jenkins, state.
Defense.
James Owens for Sarah Boone.
Tony Henderson, Sarah Boone.
Kevin Beck on behalf of Sarah Boone.
All right. Ms. Boone is seated at counsel's table wearing the same dark gray suit and maroon blouse from this morning. She is in custody. However, there are no restraints as she will be standing as with the rest of us when our jury enters and exits. It's 12:57. State, anything we need to address?
No, sir.
Defense.
Judge, I've got something. Can we approach the bench?
Yes.
I can't even fast forward past the approach. We're not behind yet. Michelle, I wonder if she got mad because he didn't come upstairs to where she was in the shower. You see, again, that assumes that hide and seek actually happened. Jay Borrego is saying, I wonder if Sarah found out she had a phone that night. Maybe. Could have been what the argument was about. As a victim gets closer to leaving, the abuser senses that loss in control, and that's when things get really dangerous. That's when they up the ante. That's when they try and hang on tighter to that control. This is why it's dangerous. If the victim leaves, the abuser loses control. And they can't have that. They can't allow that. And you've seen over the last 4.5 years how controlling she is and how angry she gets when she doesn't get what she wants. Captain D saying, here we go, another D team problem. Yeah. I think they have a difficult client. Shanna the Banana says, I have a hunch she's in the habit of surreptitiously, I missed it, I think getting the goods on someone or digging up dirt on someone, possibly. Was that what you're saying? Kat says, Sarah doesn't appear to be having a good day. On the day of sentencing, well, if she's convicted, I think, remind me, because I think we should all say we had a good day. Stephanie's asking, if the suitcase was in the back of the closet upstairs, why would it be downstairs empty? Right. Sarah was asked about that. And if you go back and listen, I did a video on that too. I think it was the car interview. She struggled. You could almost, even though it was audio only, you could almost hear her wheels turning to come up with a rationale, not expecting that question. And she said, oh, well, we were going to we're going to donate it. We needed to clean out the closet because we're going to give clothes away. But, the child's clothes that he'd grown out of were not in the suitcase. So I don't know why you drag the suitcase downstairs if you're cleaning out a closet upstairs. Wouldn't that be extra work? Right? So I think her story's bullcrap, but that's the story. Discworld Edgewitch says, a lot of people were discouraged by the prosecution's cross of Sarah. What's your take on how well the prosecution is making their case? I think they're doing well. I think they have a long game that we don't necessarily see. They have the benefit of seeing the expressions and body languages of the jurors that we don't see. They knew that this expert that we saw this morning that was flipping gold, that expert was going to be up, and everything that expert was going to say, if he's honest, would actually describe Sarah, which is exactly what happened. So they can get things out and plant seeds with the jury and get them thinking without appearing to be bullying Sarah, who's claiming she's a victim, right? So, yeah. So I hope it keeps going like that. I think they could have taken a month to disprove all her lies. There were so many. GC says that the suitcase was downstairs for a week because they were going to do spring cleaning. Yeah. Peter says, I think the hide and seek story was just the way it ordered to put the suitcase into play. Sorry, I'm just checking if we're frozen. No, we're not. Okay. Right. Someone's saying, I might, if I was planning on getting rid of it, I might leave the suitcase by the door along with other things. But Sarah said she was going to put clothing into the suitcase that she was going to donate. And the clothing was upstairs in the child's room. So why not fill it with the clothing first? Discworld is saying it could be so easy for the prosecution to get lost in the weeds with this case. Yeah, that's true. Cat Lady says, we know it was George's suitcase with his things in it. I really think he was leaving her. That's possible. For the longest time, I thought it was Sarah's suitcase. I didn't realize it was George's. And, it's only Sarah saying that it was George's. We don't know that. We don't, anything she says, we don't know if it's true. But that, yeah, possible. Dr. Barry says, Sarah logic will never make sense. Yeah, that is true. Kat says Sarah's supervising Owen's notes. Wouldn't surprise me.
All right, thank you all very much. Mr. Owens, if you could see to calling Dr. Harper at this time to advise her to be here at 1:30 for her testimony.
Yes, sir.
Just 1 second, sir. Thank you. I'm waiting for Mr. Owens to return.
She said when she was coming downstairs during this supposed hide and seek, she saw him getting in the suitcase from, she wasn't even all the way downstairs. Yet the next morning, when she's coming downstairs, she claims she doesn't know where he is. But the suitcase was there. She didn't see it then? Come on.
Appreciate it. Thank you, sir.
CJ, the defense does not want Brian on their list.
Judge, may we approach him?
Without Mr. Owens?
Yes, sir.
Sure.
Truth 17, John 17 says, I think they should show the prior body cam videos that they're telling. They might. I don't know. They might. Dr. Barry says that she personally believes that Sarah is a pathological liar and she lies to make herself look better. I wholeheartedly agree with that. And the lies change depending on the moment. She doesn't even have a long game. It was the alcohol. I don't drink. I know I can't get drunk.
All right, as we've discussed, we are not going to be having the charging conference regarding the jury instructions at this time. That will be conducted tomorrow. I have requested the defense to provide any instructions that they are seeking to be provided to the court and to the state in Word format tomorrow, including but not limited to 3.6F or 3.6G and any portions thereof that the defense is seeking to utilize for the purposes of jury instructions. The court throughout the trial has been redlining the jury instructions that were provided initially by the state. At the end of the evidence and testimony presentation this afternoon, the court will email those to all parties. Once Mr. Owens comes back in from advising witnesses of when to be here, we will bring in our jury and proceed with the evidence presentation this afternoon. State, anything else we need to address? Defense, anything else we need to address?
No, you are.
All right, very good. As soon as Mr. Owens enters, we'll bring in our jury. The deputies will assist Ms. Walker in the wheelchair into the jury box.
So I noticed, hang on. I noticed in the chat, Dr. Berry said to somebody, hey, protect your mental health. Don't try yourself to actually engage in Sarah logic. And, and she said LOL, but there is something to that. I can tell you that at work, sometimes you have to get into the head of an offender in order to figure out what's really going on. You have to try to think like them. You have to really get in their head. And it messes with your own head. So afterwards, you have to make sure that you go out and talk to real people, like normal people, right? To get your sense of reality back, you have to discuss it with colleagues. You have to debrief. You have to do a lot of self-talk to make sure that, hey, this is insanity, right? So there is a lot of mental self-care that has to go on when you're involved in a case like that. So if you look at, let's say, just pick whatever kind of case triggers you the most or upsets you the most. So you think, I don't understand that. Think of this. The fact that you don't understand might be a good thing. Sometimes the fact that you can't wrap your head around what somebody has done that's evil is a sign of your own health. So it's okay to not understand. I just wanted to talk about that for a second.
All right, everyone can be seated. Thank you. Welcome back. I hope you enjoyed your lunch. I see juror number fifth from the right to left, second row. His hand's already up. He knows what's coming. If you can, just raise those hands. Confirm you complied to the court's instructions. Record reflect all hands have been raised. All right, members of the jury, the defense is going to continue with their evidence and testimony presentation this afternoon. Thank you. Mr. Owens, you may call your next witness, sir.
Your Honor, the defense calls Ms. Pearl Walker.
So we're seeing another expert. And again, remember, the expert is there for their expert opinion. She's going to talk about the same issue we heard earlier. Facts are the facts. The research is the research. Each side, both the prosecution and the defense, can argue it from whatever angle that they want.
Deputy's got it.
Got it, okay.
Ms. Walker? Ms. Walker? Can you raise your right hand to be sworn, please? Do you swear or affirm that the testimony you should give shall be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, ma'am.
Thank you.
Ma'am, good afternoon. Could you state and spell your name for the record for us?
What did you say?
Can you state and spell your name for the record
Earl
for us?
Walker. Pearl Walker, Walker.
Thank you very much, ma'am. Mr. Beck, you may proceed.
Good afternoon, Ms. Walker. Ms. Walker, do you know the defendant, Sarah Boone?
Yes.
Hey, the defense said that she was waiting outside and they agreed not to call her. Now they're calling her?
How do you know her, ma'am? How do you know Ms. Boone? If you can't hear me, just ask me to repeat myself, and I'll
Okay.
do so.
Okay.
How do you know Ms. Boone?
She lived in the same apartment building that I lived in.
And can you tell us how long the two of you shared the same apartment complex, apartment buildings?
About 4 years.
And how is it that you became familiar with Ms. Boone?
My husband and I was sitting out on the porch, and we see her coming with her 2 dogs.
And what happened then?
Then I would call her over with her dogs.
And what do you mean by call her over?
When I see her walking with a dog, and I see her and I look at her, and I said, "Hey, Sarah, how you doing?" And that's it.
And would she generally respond to you?
So this lady is a nice old lady. She's a nice neighbor.
Yes.
And how, I won't go there. Would you spend time with Ms. Boone?
Did I spend time?
Would you spend time speaking with Ms. Boone?
Yes.
How long would you speak with her?
About 15 or 20 minutes. That's all.
And was your husband sometimes involved in those conversations as well?
He just say hi.
So you and Ms. Boone were the two primary communicators?
Yes, sir.
Okay. In the time that you knew Ms. Boone, did you witness anything about her person or her body that gave you cause for concern?
Sometimes I would see it like she had been choked around her neck or her arm be hurt. Have a mark on her arm. And I just asked her.
And would she describe how that happened?
She just say, I had a...
Hang on.
Understand.
Objection is
I can-
sustained.
When you would ask her that, how did she appear to you to respond emotionally to your questions about her injuries?
She just say, one of them days or something.
Objection sustained.
Just for the record, instead of telling us what she would say, would she demonstrate any emotion on her face?
Well, I would see the emotion that she was upset about something.
And did you ask about her obvious upset persona? Her upset, the fact that she was upset? Would you ask her about that?
Yeah, well,
Okay, you have to just limit your answer to the question. Would you ask her about that issue, or why she was upset?
Yeah.
Okay. And I'm sorry, I just can't go beyond that. Thank you. Now, how frequently would that occur?
I would say on the weekends when I see her.
Was that primarily when you saw her on the weekends?
Mostly I would see her walking through, going to her place, and and I'm sitting on the porch and I see her then.
Now, strike that. While you were there in that apartment complex, and excuse me for getting ahead of myself, do you still live in that apartment complex?
No,
Oh. How long have you been gone from that apartment complex? If you don't know, that's fine.
it's been a while.
Thank you, ma'am. During the occasions that you had,
I want to know if she left the apartment complex before or after the incident for what we're all here for. I like her. She's doing the best she can. I think she probably isn't understanding really how she is being used here. The fact that she is being used in this manner bothers me, but the witness herself, I like her. I think she's just a nice neighbor who, saw this young lady and was concerned and is telling what she perceives to be the truth. And anything Sarah said to her is going to be once again Sarah's narrative and Sarah's acting or whatever, right? But the jury is going to hear that this other neighbor saw marks on Sarah.
to interact with Ms. Boone, how did she treat you?
Objection.
She was a nice lady,
Overruled.
nice to me.
Did she ever act uppity?
Objection. Relevance.
Overruled.
Did she ever treat you in an uppity manner?
What you mean, sir?
Did she ever look down on you as a person?
Oh, no.
Did she ever
No, she didn't look down on her as a person because she was nice to her. If this woman had treated Sarah in a way that Sarah didn't like, well, Sarah's behavior would have changed.
treat you with disrespect?
No.
I'm going to object. This is character evidence.
Sustained.
May I approach on this, Your Honor?
Yes.
Yeah, this is character evidence. Modern Memes Shop is asking, why am I so biased? I am basing my judgments on the entire body of evidence that I've delved deeply into for the last few years. Am I biased? Yes, I think she's guilty. And I stated that right up front at the very beginning of this series. Is she presumed innocent unless proven guilty? Yes. If I hear something that fits with the body of evidence that is already present, that explains or mitigates or excuses her behavior, then I am willing to change my mind. But at this time, based on the evidence, yeah, I'd say I'm biased. There you have it. You can like it or hate it or think what you will of it. That's how it is. Somebody said innocent until proven guilty equals abandoning critical thought. I disagree. And the reason I disagree is because, we're hearing stuff through the media. The defendant has to have an opportunity to present their side, and all of the evidence has to be tested. There are people who are not guilty, who are convicted. So, and that it's found out later. So I'm not willing to.
Objection sustained.
Well, so I'm not willing to say, hey, let's just call somebody guilty and throw away the key without a fair trial. That is terrifying. Oh, sorry. Okay, I misunderstood. The commenter said it does not equal abandoning critical thinking. So I just went like blah, blah, blah for nothing. Sorry.
I'm sorry, I'm back, Mrs. Walker. In the time that you and Ms. Boone lived together, on occasion, did you see law enforcement arrive at the apartment complex?
A couple of times.
And did you ever get involved in any of their investigation?
No.
Were you ever approached by law enforcement and asked for information, evidence, insight into what might be going on?
No, sir.
Now, in all candor, were there occasions when you believed that Sarah Boone may have been under the influence of alcohol?
No. I can't say.
Did you also observe George Torres during the time that you lived there in the apartment complex?
I didn't see him very much. If we're sitting on the porch, that's the only time I see him.
Did you know Mr. Torres very well?
No.
Was there an incident when you saw Ms. Boone with a black eye?
Yes.
Did you witness a pattern between Ms. Boone and Mr. Torres wherein you observed signs of abuse?
Objection, nomination.
Sustained.
You testified that you saw Ms. Boone on occasion with bruises, other injuries, and a black eye. Is that correct? Is that accurate?
Yes.
And was there any pattern to what you observed in regards to those injuries and bruises that you observed on Ms. Boone?
One time I seen with a black eye and like she had been choked one time.
Okay. Did Ms. Boone complain to you about those marks?
Yes.
Thank you, Your Honor. Nothing further.
Any cross-examination?
This after they spend all kinds of time explaining why Ms. Boone would lie about how she got marks or about try and hide that there was anything going on. But to her neighbor, she complained about it.
Hi, Ms. Walker.
Oh,
Is it fair to say you're not sure when exactly you saw any of those injuries on her, correct?
say that again?
You're not exactly sure when you saw any of those injuries on her, correct?
When she come past the apartment, I'll be sitting out there, 'cause we always sit out there.
Right, but we don't know if this is December or 2018 or anything
I
like that.
can't remember, sir.
Okay. And is it fair to say you have no idea how she got those marks? Is that fair?
Repeat that again?
Do you have any idea how she got those marks?
On the weekends, I see him and her go in.
Okay. But you don't know who, if anybody, put those marks on her, right?
Well, I
Just calls for yes or no.
I can tell when they must have had an argument or something. I hear the dogs barking.
Okay. And you're 5 doors down, right? Unit 8, Unit 3?
Yeah.
No other questions?
Any redirect examination?
No, Your Honor. Thank you, Mr. Walker.
Can this witness be released?
Yes, sir.
Thank you very much, ma'am. Ms. Walker, the deputies are going to come get you and take you out, okay?
I feel her frustration because she knows what she thinks. She knows what she saw. She knows what she thinks that means. And the rules of evidence and examination and cross-examination won't allow her to just say it. And to somebody who is not accustomed to testifying, that would just seem frustrating and weird. So I do understand her sort of annoyance.
We all done?
Yes, ma'am. Thank you so much.
Yeah, Dr. Barry saying this was the only person Sarah could find to speak positively of her. That says something. Somebody who didn't even know her well, right?
Defense ready to call your next witness. Yes.
I'm going to fast forward past her moment.
Witness is running a couple minutes late. I think they may be stuck in the security line downstairs. So we're just going to be in a short recess for them to join us this afternoon. Similar things were witness.
Okay, so we're waiting for a witness. I'm just going to talk to you guys. West Rucker is asking, where are Sarah's brothers, her friends, co-workers?
Y'all can be seated. Thank you. We'll be off the record until Dr. Harper arrives.
You know, if I was on the defense side and that issue that she has no one to come forward for her was brought up, I would claim that she was just so isolated. But we know nobody liked her because of her behavior. Yeah, so someone in the chat is saying, yeah, nice conversation with a neighbor as you pass by can give the wrong impression. The neighbor can't know all the details what's going on. A lot of people have neighbors who are suffering from DV, who have things going on, who are maybe not safe people themselves, like maybe they're a threat to others. How many times have you seen the news and somebody's arrested for something horrendous and everybody says, oh, but he was such a nice guy. The neighbors come out, oh, he was quiet and normal. You don't know. Katina's asking, Lori, does the state get a rebuttal phase? Yes, they will put on a rebuttal case. What they do with that or how they do it is up to them. They're going to have to strategize about that. I think we could be here for months and months if you wanted to rebut every single lie, there is just so much wrong, so much illogical, so much that doesn't hang together that it is overwhelming. So they're going to have to pick and choose, and hopefully they pick and choose the right things. Because sometimes, a juror can hang on to one detail, and that's the thing for them. So we don't know what they're going to do. Kathy is saying Jeffrey Dahmer's neighbors thought he was a nice man. Yeah. Yep. CB is pointing out she told neighbors to mind their business. Yeah, she did tell one neighbor, if you hear anything, yeah, don't bring it up. Don't do anything about it. And by the way, if you or someone you know, someone close to you, is in a relationship that is dangerous, one of the things that you can do, or that they can do, is to say to neighbors, because people are afraid to call police. They think, gee, should I get involved? Gee, maybe it's nothing. Gee, if I do anything, will it make it worse? They have all kinds of questions going through their minds, and they're really hesitant to call, right? If you're in a situation, you can say to your neighbors, hey, by the way, I don't mind it if you're nosy. If you hear something at my place, please do call the police. So then you've given them permission. You don't have to disclose a whole lot if you don't want to, but you can tell them, yeah, please do get help for me. And if you're wrong, it's okay. So that is something that you can say to your neighbors. Kimberly thinks that the one thing jurors hang on to is going to be the suitcase video. Regardless, so somebody's saying, yeah, Sarah's brother was in trouble with the law, but it's not relevant. Oh, wow. AD is saying, I had a coworker that I would have sang her praises, but then had the opportunity to be around her outside of work. 2 different people. Yeah. A lot of times people are completely different behind closed doors. I have seen accused offenders get on this, be in the box, and neighbors, friends, coworkers come forward and say, he's so charming. He's so wonderful. And the victim looks crazed because she's traumatized. And no one can believe that he could have done this thing. And they'll come forward and act as surety or post bond for them and testify on their behalf. They get their ministers in. Oh, he's such a loving man. Yeah. Behind closed doors. Dennis Rader was a deacon at his church. So just because somebody seems wonderful doesn't mean they're. Actually, I think the people who look good on the outside, who are charming, who have, high status jobs or positions, to me, they're scarier because people trust them. And I think they get away with things for longer because people believe them. Dr. Tracy is saying Gabby Petito, the cops in Utah, thought she was the aggressor. Bundy, yep. Robert says they always say watch for the quiet ones. Kim is saying often they can be very charming. Yep. And there are functioning psychopaths too who aren't, doing engaging in all this horrific stuff we're talking about, but they still have the behaviors, right? They still will abuse. It's just not, doesn't happen to be illegal. What, so was there a troll in the chat and I missed it? I think I've missed a couple of them. It's probably good I didn't see it. Robert says, yes, Bundy was considered very charming and handsome. And at one point, he was friends with a number of police officers. He worked on a crisis line. He one time called and
We
tried
are
to
back
confess.
on the record. Case
And nobody believed him. They laughed. They thought he was kidding.
number 2020 CF 2603, State of Florida versus Sarah Boone. State.
Judge, before we began trial, I had indicated that in the past, historically, in these types of cases, there were problems with cameras showing attorneys' laptops. It's been brought to my attention that that is going on again. I'm asking the court to order whoever it is who has a camera, whether it be a phone or the court TV pool camera, that they not do that.
Okay. All right. Members of the gallery, good afternoon. And the TV crews as well. Information that's contained on both parties' laptops, be it the defense or the state, is protected by work product and attorney-client privilege. It's not something that's viewable, not something that should be disseminated, and not something that can be looked at unless there is a knowing, intelligent waiver, and that stuff's going to be put out to the public for consumption. So I'm going to ask you as best as possible not to view, take pictures of, or look at any of the laptops, be it the defense's laptops or the state's laptops, to avoid that. With regard to the camera, if we can, when zooming in on either the defense counsel's table or the state's counsel's table, if we can try to avoid their laptops, I would greatly appreciate you, sir. And the podium. Thank you.
I hope I'm not losing my feed here. Hey. Oh, good. Okay. Purple Butterfly saying, yeah, John Wayne Gacy was very prominent in his neighborhood. Yeah. J Mac is mad. I'm missing something in the chat here. The gallery was just cranicked. Lisbeth, Colonel Russell Williams. Yeah. That one, most of them don't scare me. That one did. Probably because of my own bias. Had I met him myself, like outside of all that, I probably would have respected him. He that one scared me. So I am going to... Oh, Lula's asking, do you think the state was able to do an MMPI 2? I don't know. We're going to find out. I want to see what the lie scale says on that, right? Dirk is saying, Ted Bundy was smart. Sarah Boone is an idiot. She's not organized, that's for sure. Dr. Barry is saying, I hope the forensic psychiatrist did testing. I think she only met with her for 2 hours. Wow, that's not a long time to meet. I am going to switch screens here for a second because I just want to double check that my stream is okay. So I think it's fine. I think it's their feed.
Yes, sure, on behalf of the state.
Defense.
James Owens on behalf of
Hang on.
All right, we are back on the record. Case number 2020 CF 2603, State of Florida versus Sarah Boone. State, appearances for the record.
Dave Castro on behalf of the state.
Defense.
James Owens on behalf of Ms. Boone.
Tony Henderson for Ms. Boone.
Kevin Beck on behalf of Sarah Boone.
All right, Ms. Boone is standing at counsel's table wearing a dark gray suit and maroon blouse. Let's go ahead and bring in our jury as Dr. Harper is here.
I see people in chat are loving on Dr. Barry. I agree. If you haven't checked out her channel, do so. I am one of her subscribers.
All rise, jury room.
State, you recognize our jury.
Yes, Your Honor.
Defense, you recognize our jury. All right, thank you. All could be seated. Again, members of the jury, if you could, just raise those hands, confirm you complied with the court's instructions. Record reflect all hands have been raised. All right, defense, at this time you may call your next witness.
We call Dr. Julie Harper.
Do you swear or affirm that the testimony you should give shall be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Doctor, good afternoon. Could you state and spell your name for the record for us?
Dr. Julie Harper, Harper.
Thank you. Counselor, you may inquire.
Thank you, Judge. Good afternoon.
Good afternoon.
I think you've already stated your name, but just introduce yourself to the jury.
My name is Dr. Julie Harper, and I'm a licensed psychologist.
Would you tell the jury your educational background?
I have an undergraduate degree from Oberlin College in biopsychology. I have a master's degree from University of Denver. I went on from my master's degree to earn a psychological doctorate. That's called a PsyD. That was also from University of Denver. In completing that education, I specialized in psychological assessment, which means I had extra coursework in that area of learning to administer psychological tests to other people. I completed an APA-approved internship at Washington State University, which means that I was matched, and that was my site to practice being a psychologist for a full year, and that was between 1999 and 2000. And following that, I turned in my dissertation, which was in the passing of power in couples relationships. I then graduated and started my postdoc work in Pullman, Washington.
Gonna stop here. So definitely she's a qualified psychologist. There's no question about that. What I'm listening for and hoping for is whether or not she is a forensic psychologist. It does make a difference. It's not that she is less qualified if she's not. It's just forensic psychologists deal with that intersection between the psychology and the law. The other thing I notice here that she has expertise in couples counseling that is not the same as expertise in DV in particular. They're two different kinds of animals. That doesn't mean that she doesn't have the other expertise. We haven't got there yet. So those are the things that I'm thinking, and those are the things that I'm watching for. I don't think that she is not qualified, though.
As part of becoming a psychologist, you have to have over 1,500 to 2,000 hours of supervised work as a psychologist. The person that supervised me was a forensic psychologist. So during that postdoc time, that was my introduction to forensic work while I worked at a community mental health center.
So I'm corrected.
Dr.
Good.
Harper, how long have you been licensed?
I was first licensed in Washington State in 2002, so 22 years.
What type of position have you held as a psychologist?
Well, I was rehired at my internship site, so I worked at Washington State University College Counseling Center. I also worked 2 times at a community mental health center. The first time was in Pullman, Washington, and that was during the period of time where I was getting my postdoc hours completed, and then I stayed on after licensure. I also worked in Florida. When I came to Florida in 2005, I took a position in the Fort Walton Beach area at Bridgeway Center, which is the community mental health center. And while working there, I completed a variety of psychological assessments. I was directing the testing program. I also began working doing the Department of Juvenile Justice contract work for evaluating adolescents that had gotten into legal trouble and needed an assessment for consideration of program placement. I worked in that community mental health setting doing clinical assessments and the DJJ contract and Social Security evaluations, and continued that until about 2010. In 2010, I opened my own private practice, which is Northwest Florida Psychological Services. And in the beginning of the practice, it was a combined clinical and forensic practice, meaning that I spent a majority of time doing psychological assessments to answer questions from physicians about things like ADHD, depression, to make treatment recommendations. I had the therapy patients, and I also did, again, Social Security disability evaluations, so numerous kinds of assessments. And then over time, I began...
Okay, I'm looking at the chats, and I want to respond. First of all, just like the earlier expert witness, she has to say all this stuff so that they know indeed that she's qualified and what those qualifications are. Okay, so there's nothing wrong with that. Somebody's commenting about how she's smiling a lot and her mannerisms, and I'm going to tell you, it's really hard to get up on the stand as an expert witness. You know you're under a microscope. You know you're being judged. You know one side hates what you're going to say. You want to appear likable, but not too likable. And for women in particular, if you don't smile enough, you're criticized. If you smile too much, you're criticized. If you're a female professional in the criminal justice system in one of these roles, you get judged harshly. I just want to make those remarks. All of the other remarks I made about expert witnesses in general, the ones I made this morning, hold equally as true for this expert as the male expert. It is the same.
Doing more and more forensic work, including receiving appointments from judges to do competency to stand trial evaluations, sanity at the time of the offense evaluations for Circuit 1 in Florida. And I continued to do the Department of Juvenile Justice contract briefly, but then that it came up for bid and I discontinued that contract. What I did is I slowly reduced my clinical practice, because when you do forensic psychology, it means you have to travel. Your individuals that you're seeing are not usually out in the community. A lot of times you have to see them in jail. So it's hard to maintain a therapy practice, and I scaled that back over time. Eventually, my practice became entirely forensic. And then in 2017, I took a job with the state of Georgia to be an evaluator full-time. I was working doing competency to stand trial and sanity at the time of the offense evaluations, and then assisting with risk assessments in the inpatient setting. I did that until 2021. At that time, my private practice was just it quieted down, of course, from COVID, and I was not in full-time practice, so I wished to return to full-time practice with my own company, and I did that in May of 2021. And since then, obviously the courts are busy again. We're all recovering from the COVID era and back to full-time practice.
Now, where do you live?
I live in Okaloosa County, and that is in the panhandle of Florida.
All right. And is that where your practice is currently?
Yes.
All right. Is it fair to say you travel the state to?
Bless you.
Is it fair to say you travel the state to do assessments or evaluations?
That's correct. I travel to a lot of cities throughout Florida, as far south as like Miami, and then, of course, working along other
Is it
cities.
fair to say that you testify in various counties throughout the state?
Yes.
And I know that yesterday you were set to testify in Bay County, Panama City.
That's correct. I was testifying yesterday in a death penalty case in Bay County.
All right. And when you finished, you drove here?
Yes, I did.
My understanding is you got here after midnight.
Yes.
What other counties have you testified in?
Well, I've testified here in Orange County, in Miami-Dade, in Duval. It might be hard for me to list everywhere. Alachua, Escambia, Santa Rosa County, Walton County, Bay County, Washington.
So just so the jury understands, the nature of your practice is you have to travel throughout the state.
Well, I do work in cases where the person is at risk of, succumbing to the death penalty. And so those cases require repeated evaluations in different vicinities. And so I have been, traveling to work on murder cases. There are psychologists, I suppose, that do forensic work that might just confine their work to one circuit or stay. But I actually broadly travel.
You said that your practice is now entirely forensic?
That's correct.
What you said? And you've testified about what kind of forensic work you do?
Yes. So as a forensic psychologist, sometimes I am tasked with testifying about something very specific. So for instance, a person's ability to stand trial if they're knowledgeable and can go forward with their trial process. I've testified about a person's sanity at the time of the offense, meaning if they had a mental health condition that met the statute as to not being sane at the time of the offense. I've testified in sentencing hearings. The majority of my work comes through with that court-appointed funding. Percentage-wise, probably about 90%.
Okay. Now, I realize you testify on occasion by the state, but the majority of your time, 90%, 95% of the time, you testify on the behalf of the defense?
Yes, the evaluation's complete, and either side can call me for testimony.
My feed's wonky. I'm going to switch feeds. Sorry, guys. But I want to see everybody's...
And
I want to see everybody's face and expression and everything while they're talking. So I am just going to quickly switch feeds. Here we go.
And over time, I began...
The state to...
Bless you.
Is it fair to say you travel the state to do is where you're paid by the government to do the work?
Oops.
I would say that the majority of my work comes through with that court-appointed funding. Percentage-wise, probably about 90%.
Okay. And I realize...
Okay, so in case you missed it, because I was fooling around with the feed, he was asking, because people in the chat are interested in how much she works for the prosecution or the defense, and she is saying she works, most of her work is coming through the publicly funded end, which suggests to me that it's for defendants, but I'm going to rewind a little.
You're appointed by the court to provide the service that you provide, and you're paid by the state.
That's correct.
What percentage of your work is where you're paid by the government to do the work?
I would say that the majority of my work comes through with that court-appointed funding. Percentage-wise, probably about 90%.
Okay. And I realize you testify on occasion by the state, but majority of your time, 90%, 95% of the time, you testify on the behalf of the defense?
Yes, the evaluation's complete, and either side can call me for testimony, and the majority of the time I'm called by defense.
And so you make a living by traveling the state, and generally the court system, I think they call it JAC, pays your fees.
So I make a living by performing work as a forensic psychologist, evaluating individuals, most of the time that are incarcerated in a prison or a jail setting, providing consultation to attorneys who might just have questions that would...
I'm really glad she clarified that, because she's making a living not off of JFC, but from her expertise.
Need a psychological expert to explain something to them. I also do fitness for duty evaluations for law enforcement, pre-employment evaluations for law enforcement and firefighters. So depending on the work that's needed, I do those.
Doctor, how is a forensic psychological evaluation different than a regular psychological evaluation? Can you tell the jury?
Sure. So if any of us went into a psychologist's office and had an evaluation done, it would be most likely for treatment. So things like if you qualify for surgery or you're going to have treatment, maybe you've got a condition that you want therapy for. A psychological assessment is very helpful in identifying a diagnosis and then setting a course for treatment. A forensic psychological evaluation has many of the same procedures, but the aim is really different. The aim would be to answer some kind of legal question that is posed. So as an expert, I might be in the position to provide some education or experiential descriptions of something that a person might be suffering from to people that are going to make a decision. So for instance, if it's a competency evaluation, I would educate the fact finder. In that case, it would be a judge about what is wrong with the person, or if they had any deficits at all, or if they were competent to proceed. In a situation like this, a forensic psychological evaluation might be geared more to identifying, again, if there is a mental health condition present in the defendant I'm evaluating, and then to provide a jury with education about what I found in my evaluation.
How many forensic psychological evaluations have you conducted? Estimate.
So just as an estimate, it's clearly more than 4,000. I've been doing forensic psychological evaluations as far back as 2007.
Have you been qualified as an expert to testify in forensic psychologist in court?
Yes.
As a forensic psychologist?
I have.
And you said you've testified for the prosecution?
Yes.
And you've testified for the defense?
Yes.
Is there any difference in the work that you do depending on who hires you? Which side?
Absolutely not. A forensic psychological evaluation is an objective assessment of what's going on with the person. So you should be performing the same kinds of procedures in doing the evaluation. It should not matter who's retained you. What you're trying to do is answer a question.
Are there times when you actually do an evaluation and assess an individual, but then you're not actually called to testify?
Yes, many times that's the case. You will provide your feedback to the attorney, and then it's up to the attorney to decide if there's anything in there that would be useful to them, or if they're pursuing a certain kind of information for the court, they would choose to call you for testimony.
Dr. Harper, do you recognize Sarah Boone at the defense table with Tony Henderson?
I do.
When did you first get involved with Miss Boone?
It would have been in around June of 2020. It was the first I heard of her case.
And what were you asked to do?
A comprehensive psychological evaluation of Ms. Boone.
And did you do that in Ms. Boone's case?
I did.
Okay. Were you given materials to review?
I was.
Is that standard operating procedure?
Yes.
You assess the client individually, one-on-one, and then there are collateral evidence or material that you also consider?
Yes.
Can you tell the jury about that?
Yes. So in forensic work, there are a variety of documents that are usually available in assessing a defendant. In this case, for criminal court, you would see things like witness statements. There might be body cam footage or just more information about the offense itself. Sometimes there's an interrogation video. So you would get kind of the legal description of the offense and the things that have occurred. I also will often get educational records of a person, mental health records, hospital records, things of that nature that would describe their biopsychosocial history to me.
And you were given materials as it relates to Sarah Boone to review?
Yes, I have it.
How many times did you meet with Sarah Boone?
So 9 times.
All right. Can you tell the jury what you did as part of your evaluation of Sarah Boone?
If they met 9 times, I would like to know the total number of hours that were spent over those 9 times.
Well, we had clinical forensic interview in which I reviewed her background history, so her early childhood. I also assessed her with assessments, meaning I administered 3 psychological tests to her. I reviewed her prior mental health records, her interrogation video, some prior information about her legal history. So she had been previously arrested. I reviewed that as well. We had an opportunity to review the transcript of her interrogation video. So there were a variety of things that would be considered what I did with her.
Okay.
Her interrogation video, did this doctor actually watch the video or just read a transcript, because they're going to come off different? And I'm not hearing that she saw the suitcase video, because there's some pertinent information in there.
So you considered some medical records?
Yes.
And did you also consider some records from George Torres's records?
I did see his hospital records.
Now, do you consider, in doing an assessment and forming any opinions, an individual like Miss Boone's upbringing in terms of where they grew up and what their family environment was like?
Yes, that's part of gathering their background history, so biopsychosocial information.
And did you consider Miss Boone's upbringing in forming any opinions?
I did.
Can you tell us a little bit about that?
Yes, so of her history, I found it pertinent that she was raised with...
Conduit 704.
Roach.
Yeah, relevance. Lay the foundation if it's relevant. Whoops. I accidentally just turned this up. I was trying to fast forward.
Family background. Consider.
Stayed.
Would you have considered, as part of her family background, whether or not some of her family members had passed away early in her life?
Objection. Leaving Conduit 704.
Sustained.
Do you consider the entire family background and history without going into the details of what she said or what you learned from looking at records? I'm sorry?
The state objected rightly and won that. But, the jury still heard that, and Owens knows it, right? It's going to be hard for them to unhear it. And it just all goes to, oh, this poor woman, poor Sarah, woe is me.
Yes,
And did you consider her relationship with her mother as part of her psychological development?
yes.
Now, do you believe that Sarah Boone does have some narcissistic traits?
I do.
She doesn't qualify or meet the criteria for that diagnosis, does she?
I did not diagnose her with that.
Can you elaborate?
Hold on. Those are two different, the question and the answer are different. She has narcissistic traits. Owens asked, did you diagnose her with that? The answer was not a simple no. The answer was, I did not diagnose her. That is different.
Elaborate on or explain how you feel that Sarah Boone does have some narcissistic traits?
Well, in meeting with her as part of the evaluation, the narcissistic traits that I identified would have to do with, as she described, being a straight A student. She reiterated about her abilities, and I felt that that was evidence that she had low self-esteem, and her coping mechanism was to identify what made her stand out, and that would be consistent with a narcissistic trait.
Now, I know there's been reference in this case to a manual that all psychologists, all psychiatrists refer to. Do you have that manual with you?
I do.
And what is the name of that manual?
It is the Diagnostic and Statistical Manual of Mental Disorders, the text revision. So it's the DSM-5 text revision.
Now, Dr. Brannon testified earlier today, and there was some evidence relating to when you suffer from narcissism, there's a sense of grandiosity. But is that from this manual and your studies and your experience, where they require excessive admiration and whatnot, that there's a reason for that?
If I'm understanding your question, there's a criterion in narcissistic personality disorder related to that.
What I'm getting to is many times.
Oh my gosh. If you can't, what is that saying? If you can't get him with facts, baffle him with BS. He's playing around and trying to get her to say a specific thing that he wants her to say. She's not going to say it. This is his own witness, for Pete's sake. Oh my gosh.
Times you may have these narcissistic traits, but really you suffer from very low self-esteem.
That's the underpinning of that criterion.
Would you explain that to the viewers?
If I'm allowed to reference the DSM, then I can explain it best.
Okay, they're going to say that all of this behavior of Sarah's that's so bad is because she has low self-esteem, specifically what seems to be narcissistic traits. And they're going to talk about that. And Owens is going to make it sound like she has low self-esteem because of the victim in this case. But I would suggest to you that she had these traits and behaviors before she met the victim. So, you got to question that. They're not asking when these traits popped up. They better get into that if they're going down this road.
Just don't read from it. Just
All right.
You need to review. If you need to read a paragraph and then explain it to the jury.
So based on the description in the DSM, if a person's self-esteem is very fragile and they have low self-esteem, they may require more outside admiration or even appear more grandiose in their abilities, because at root they don't feel secure and confident. And so it's what we would call a defense. And so that criterion is actually a way that a person tries to make themselves feel better.
All right. Anything else you want to say about that issue?
Well, You asked me about why I didn't diagnose narcissistic personality disorder. And again, from the DSM,
Are there criteria?
there are criterion for each disorder.
And so when you're assessing someone, they have to meet all those criteria for you to form that opinion that they actually suffer from that disorder?
Well, the first, I guess, issue is, do they have the criterion that are listed? And then the second would be, is there a different mental health disorder that would better explain the criterion that you're seeing?
Remember, you heard this from the other expert this morning, right?
The criterion within the DSM overlap considerably across disorders. And so there are some helpful guidelines within the DSM to remind you of that you may have what's called differential diagnosis. So if you're considering one thing, that you also are directed to look at other things. So that happened in this case, in this instance, that the DSM guided me to also look at other things.
But just for purposes, to make it clear, you did not diagnose her as with narcissism, that disorder.
That's correct, because the DSM's description guided me that that would not be an appropriate diagnosis.
Why did you not diagnose Ms. Boone with a personality disorder?
Well, first of all, it has to be a pervasive pattern of distorted relational abilities. So basically, if she is demonstrating in a variety of settings that she has these symptoms. And then secondarily, the diagnosis of post-traumatic stress disorder is listed when you're considering personality disorders. The DSM guides you that if there are personality changes that are associated with the exposure to a trauma, then you should consider post-traumatic stress disorder and not a personality disorder.
Have you diagnosed her with anything? And we'll elaborate on that, but through your assessment, have you diagnosed her with anything?
Yes, so she has a diagnosis of post-traumatic stress disorder. She has symptoms of anxiety that would be consistent with post-traumatic stress disorder. So that is an anxiety disorder.
And you feel like she suffers from post-traumatic stress?
I do.
Now, at the time of this incident, this event, we're talking February 23rd of 2020, you were aware that she did not have much family support.
Yes.
Doctor, why do you administer psychological testing?
Psychological testing allows an objective measurement of what the person...
Just going to stop for a sec to point out that PTSD and any kind of personality disorder, any disorder that doesn't cause like a psychotic break with reality or an inability to tell the difference between right and wrong, those things are not a defense to criminal acts. Secondly, we have not heard yet, and I don't know if we will, when this PTSD surfaced.
Symptoms may be as compared to sort of an average. So if we can see what the average range on a standardized measure would be for any person, if there is an interpretable difference, that gives me clinical information. So it's not just relying on what the person has told me. I've got an objective measurement that I can compare to other people. And then I also administer psychological testing in a forensic evaluation to help assist me in making sure that the person is intending to put in good effort with me. In some forensic settings, a person may have a reason to present symptoms, like if they're in a custody evaluation, for instance, they might have a reason to minimize symptoms, or they may exaggerate something else. And so assessments as to the person's response to you and if they're validly participating are important.
So there are tests to see if you're faking or malingering or that type thing? Right.
And so you would call it feigning mental health symptoms when the person is either far exaggerating a symptom they do have, or if they're pretending to have a symptom that they do not actually have.
Okay. Now, as it relates to Sarah Boone, What type of psychological testing did you administer?
I administered the inventory of legal knowledge, and that is a test that has to do with whether or not she was validly participating regarding her understanding of the legal process. I also administered the Miller Forensic Assessment of Symptoms test.
Now, explain to the jury what that Miller Forensic Assessment of Symptoms test is.
So that is also a test of feigning to identify if she's validly participating in the evaluation. So if she had endorsed psychological symptoms or psychiatric symptoms, that would be unusual or not typical of a valid psychiatric patient.
What were the results of Ms. Boone's?
I want to know when those two tests were administered, and I want to know what Boone got from the library before those tests were administered.
Test on the Miller Forensic.
She validly participated. There was no indication of any feigning or malingering.
And as far as the inventory of legal knowledge case, what were the results?
Again, she was validly participating, and she did not even come close to the cutoff that would put her in the range of feigning.
Can you tell the jury what the purpose of the clinician-administered post-traumatic stress disorder scale is?
Yes. So that would be considered a very useful assessment of post-traumatic stress disorder. It allows me to interview a person about exposure to a traumatic incident and then identify if there's a change in behavior that has occurred as a result of that exposure to trauma.
At the time that you administered that test, did Ms. Boone in fact have post-traumatic stress disorder?
Well,
Or tell me the results. Just
yes. So the results would be consistent with a person having post-traumatic stress disorder. I do not diagnose from one test. That wouldn't be appropriate, but it is consistent with the background and the symptoms that I had previously, taken down during my evaluation of her. So the clinical portion, when we go through symptoms, that was consistent with the outcome of that test.
And would this testing, all the testing, help you determine if Ms. Boone had a change in functioning from before the alleged trauma to after the alleged trauma? And I'm referring to the trauma. We're going to talk about what the trauma was, but the trauma was the intimate partner violence?
That's correct.
Okay. But would that testing help to determine if she had a change in functioning from that trauma of the intimate partner violence?
Absolutely.
And did you determine that she did suffer from trauma as a result of intimate partner violence?
That was my conclusion. Yes, that's my opinion.
Now, in considering all the available information, you don't just rely on what Ms. Boone tells you to make your decisions.
No, I don't. I do interview a person as part of the clinical forensic interview, of course, but I also consider things that are reported, like in their arrest narrative, witness statements, all of the medical records. So there are a variety of sources of information, collecting data points and reviewing those to arrive at a conclusion.
So you did review Ms. Boone's previous diagnoses in her history?
Yes.
Did you consider the previous diagnoses in arriving at your own?
I did, yes.
What did Ms. Boone, what had she been diagnosed with prior to you getting involved?
Objection 704 conduit.
Approach.
This is very interesting. I have questions, but they might get answered, so I don't want to interrupt to ask questions. I'm just going to fast forward. It is possible. Whoops. I've said before, if you take the stance that victims must be pure as the driven snow, you're going to run into some cognitive dissonance. I believe that there were times that she did suffer, right? That doesn't make her not guilty, right? That doesn't equal battered spouse, doesn't mean that she wasn't a primary aggressor, all of that.
But you would agree, and I think this is a fair question, you would consider prior other experts who may have diagnosed her with something?
So I would definitely consider her mental health records, diagnoses previous clinicians may have arrived at the time
Okay.
when I diagnosed her myself.
Okay, and given the assessment that you did with Sarah Boone, and considering the totality and the time you spent with her and the other records, did you diagnose Sarah Boone with anything?
Yes, so post-traumatic stress disorder, it's my opinion at the time of the offense she had depression and she had an alcohol use disorder.
All right. I know we've talked about post-traumatic stress disorder. I don't know if I need to ask you anything further. I think the jury probably understands.
Okay, at the time of the crime, alcohol abuse disorder, depression, and she's saying post-traumatic stress. So she still hasn't sort of narrowed down as to, for sure it was from a specific incident. Whoops. The depression and the rest of it was before Mr. Torres, and none of it equals homicide. So
Understands that. Is there anything else you wanted to add about that disorder?
I'm not sure what the jury's already been told about post-traumatic stress disorder, but in Sarah Boone's case specifically, because of enduring, she specifically noted the time that she was stabbed with the knife as being an extremely...
Sustained.
You have viewed Have you viewed some exhibits involving her being stabbed?
I think that we have had exhibits in common. I'm not sure what was...
it's interesting. So the prosecution moved to strike her remark about her PTSD coming from the knife incident. But there is nothing saying that it came from the fact that he did that. Given Sarah's own description of that incident, the big thing for her wasn't that he did it to her. The big thing for her was the blood. I almost bled to death. That was the big thing. That was the scary thing, the traumatic thing. So I would have been interested in sort of delving into that further and parsing that out a little more closely.
Admitted.
Have you seen the physical scar from Sarah Boone being stabbed in the back of the leg?
Yes, I've seen her scar.
Right, you're saying?
Overruled.
Just generally, without getting specific, I think I've explained post-traumatic stress. But if there's something else the jury you believe the jury needs to know, but it's a sort of trauma that occurs as a result of one or more events.
Post-traumatic stress disorder is the psychological after effect of being exposed to a very significant stressor or cumulative stressors that make the person's behavior, thinking, and mood change. And so the change can include things like the person becomes hypervigilant, is easily startled, has trouble thinking, has trouble sleeping, so their body is in a state of agitation. It can also include changes in mood that would include irritability, difficulty relating to others, and that they might be resistant to trust easily. So those are all
They have
features.
trouble sleeping sometimes.
Yes.
Sleep deprivation is a real issue.
It's associated with things like nightmares and having trouble settling.
Now, you mentioned that you had diagnosed her with depression. Can you just give us a general understanding for the jury of depression?
So the persistent sad mood, including feelings of hopelessness, helplessness, having difficulty concentrating, sleep problems, changes in appetite, those would be typical of depression.
And Sarah Boone suffered from that?
Near the time of the offense, yes.
All right, can you explain to the jury alcohol use disorder? That's a fairly new name. That's 5 or 6 years ago. The manual came up with a different name.
It did, right. And so that would be, in layman's terms, we might call that alcoholism. It's a tendency to drink too much and then have some kind of consequence in your life as a result of your substance use.
And alcoholism can be depending on how much you drink and then how often you drink.
That's right.
All that is something that you would consider in diagnosing.
Yes.
The many people who suffer from alcohol use disorder, I don't know how to put this, are they in denial?
I would say that that is one of the stages of alcohol use disorder and amenability to treatment. So in denial, it's because you do not want to acknowledge that there are consequences from your use, because in doing that, you might have to reduce how much you're using. So to deny means that you feel that you can continue your use without having to change that. So you want to maintain the access to the substance.
You don't have a problem.
That's right.
What is the difference between traits and a diagnosis?
Well, we all have personalities, and so you're going to have coping mechanisms that include personality styles. So, for instance, even though you might not be diagnosable as something, there are times when if you're upset, hurt, frustrated, you have a mood state that's unpleasant, you're going to deal with that by using some kind of coping mechanism. So traits of personality disorders might be present in the way that you deal with inner pain, things that you don't like, feeling. So some people, for instance, if they feel uncomfortable, they may cling too much or become excessively bonded to try to escape a feeling that they don't like, and that might be a dependent personality trait. It doesn't necessarily mean that they have a personality disorder, because that would have to be pervasive across all the environments. But when stressed or upset or not feeling good, you're going to use some kind of coping mechanism, and that might be one of the criterion, for instance, of the personality disorder. You would call that a trait.
And is it your understanding that this trauma that one suffers from repeat domestic violence can cause one to be considered suffering from the syndrome, we call it battered spouse or battered woman syndrome?
Yes, so the diagnosable condition would be PTSD, or post-traumatic stress disorder. That's how a clinician would label the response to trauma. The pattern between partners, the person's coping mechanism because of that trauma, that would be what's considered battered spouse or battered partner syndrome.
And you're aware that concept of being traumatized by the battered spouse syndrome or the post-traumatic stress is relevant to a self-defense case?
Yes.
In a criminal context.
Yes, I understand that.
Could you tell us a little bit about that?
Well, under the battered spouse syndrome, the person would experience a trauma or a situation in which they feared harm. And based on that fear of harm, they would react in a certain way that might not be understandable to other people.
What she's saying here is correct. But let me ask you this. So wait, let me back up and give you an example. If you got hit a lot, when someone raises their arm, even though they're not a threat, you might react, right? It is automatic. You're going to react, and that is a trauma response. Okay, your brain perceives them as a threat even when they're not, and that's what they're going for here. And the defense is going to try and explain why George sticking his hand out, which I don't believe ever happened, but that's another thing, would be perceived as such a threat by her. So as you're listening to the expert, understand that what she's saying is correct in terms of what the body of knowledge is, right? But you think for yourself and apply it to Sarah in this situation, given everything you know, given all of Sarah's own statements, given that video, all of it, how she was not hypervigilant all day, how it was a good day, all of that stuff. And you decide whether you think that these elements that she's going to describe here actually applied to Sarah in this particular situation.
So their fear is based on the pattern of behavior between them and their partner. That might not be the case for another set of people.
Now, I know that Dr. Lenore Walker is the one who first uncovered this syndrome back in the 70s.
Her research study generated the term. She was interested in why battered women specifically at first, that was what was studied, didn't leave their partner because, of course, they're experiencing traumatic events, risks to their life, but then they didn't leave. So she undertook the original research study on that.
And just briefly touch on, because I know Dr. Brandon has this, there was a 3 stages that Dr. Walker developed for that syndrome.
I think you're referring to phases that a person may go through, or the cycle of the relationship. That includes the tension building phase, in which there is...
I almost don't want to listen because we know what's going to be said, but don't worry, I'll play it. Remember, the state gets to cross, and the state's going to have their own witness. And don't assume that everybody on the jury is just going to be hoodwinked automatically.
The first instance that tension is building within the partner, there might be a change in tone, a signaling that there's a difference in agitation. The second is the true battering event, so something has happened between the partners that's violent in nature. And then third, there is the honeymoon phase, which is to keep the relationship intact. The batterer would engage in what's called honeymoon behaviors, like trying to repair the relationship, apologize, essentially keep the victim from departing from the relationship. So those are 3 phases.
And is it fair to say that psychologically the abuser, does alcohol often involved in the abuse?
Yes.
And as far as the victim is getting abused, and you say it's a cycle, is the victim, when they go through that last stage, the honeymoon stage, are they thinking, okay, it's going to be better?
Yes, the hopefulness in that, trying to believe that the behavior has changed, that they're not going to be abused again, the hopefulness to maintain the relationship, to forgive. That's part of that last stage, phase 3.
Oh, you mean like when Sarah went to George's house to go get him and drag him back? That? Where she convinces him to come back? That stage, the honeymoon stage? That what you mean?
Maintaining the relationship.
I don't think I've asked this. Why would someone who has been exposed to intimate partner violence perceive the likelihood of a new violent event about to appear? Why would they perceive the likelihood of that violence differently than, say, a normal person?
Well, Well, it speaks to the pattern. So any relationship will have its own special pattern, that you have things that only your partner knows about you, or certain looks that you give that mean something, and you learn that over time. So over a period of incidents, basically, the victim begins to perceive cues that would signal impending danger. Those cues could be really subtle, just a change in tone, or some small behavior that might not mean much to another person, but it has preceded other violent acts. So, for instance, if your husband decides that he is not going out that night, he might put on different clothes to stay home, and that could be a signal, like abuse and violence has occurred in his stay-at-home clothes, for instance. That might not mean much to another person because, again, it's specific to that dyad. Those two people know those patterns. So the victim may perceive a small or subtle change in their partner as a cue because they've become hyper-vigilant. The body knows when it's experienced a threat to itself, and it will take note. We record memories differently when we're at risk. So these subtle cues become very well memorized by somebody who's being victimized.
Now, on this, and battered spouse syndrome is a subset of post-traumatic stress disorder, which you've diagnosed Sarah Boone with. When those personality changes occur, and they persist after an individual has been exposed to this extreme stress, is that when the diagnosis occurs?
The changes would be as a result of the pattern. The person experiences a change, like in their sleeping, in their hypervigilance. That's when you can diagnose it. So you can have a trauma or an experience of a scary incident, but it doesn't mean that you will absolutely have post-traumatic stress disorder. You have to have those reactive symptoms that would suggest that it's present.
In your opinion, and I know you've gone over this event with Sarah Boone, this February 23rd, 2020 event, is your opinion that she was suffering from battered spouse syndrome at the time of that event?
Yes, she had the patterns ingrained in her behavior that would be typical of a victim who's responding to traumatic events in a predictable way. So that would fit that.
Then it's fair to say that because of the intimate partner and the prior violence, that you would have a heightened sense of when danger was about to occur.
Yes.
When a threat was about to occur.
Yes.
Threat of danger.
That's right.
Every soldier knows that's true. Every cop who's worked on the street knows that's true, that you will notice things that other people won't. Your head's on a swivel. You know what I mean. The defense still has a ways to go here, though. I'm not liking this. What she's saying is correct. Like, I can't take issue with what she is saying. I'm taking issue with how it's going to be used.
Now, I want to talk about placating the abuser. A victim placating an abuser. Are there predictive cues which an abuser may exhibit to a victim that result in a high level of anxiety arousal, in which the battered woman may attempt to reduce through several different means to delay the beating? Can you explain that?
Yes. So the phase of the relationship that starts with that tension building, that is a jumping off point potentially. So if you can stop the escalation, you might stay in phase one for a period of time. Phase one being that tension building phase and trying to reduce it and not allow it to escalate. So placating the abuser might include distraction. It could include substance use. It could include a change of scenery. There are a lot of things that a partner will learn to do so that they don't have the escalation into an abusive event, if possible. doesn't always stop it.
Oh, you know the defense is going to use this and twist this. You heard Sarah on the stand, but there is another way to look at all the things that Sarah did, because she also did these things with her lawyers who weren't, causing her to fear for her life or weren't coming after her, right? All of this serious, profound control. Sarah was engaging in coercive control, and she is going to try and make it sound like she needed to placate him. And I said in an earlier video, might have been during her direct examination when I was so mad, that as she spoke and gave her narrative for the day, she refers to lightening the mood and this sort of thing, when she'd already described the mood being light and hadn't brought up hypervigilance. She said the words at one point. It's like, I'm supposed to say these words, so I will. But then what she actually describes is tension building up in her own self, not between the two of them. So, go back and look at some of those comments. They're gonna twist this. That's what this is. This expert is not sitting up here lying or anything like that, I don't believe. It's that the defense is just gonna twist it and try and gaslight the jury, just the way Sarah tries to gaslight everybody.
Now, in reviewing all of the data, all the reports, medical records, and whatever reports you considered, videotape that you may have watched, as it relates specifically to Sarah Boone, are her words her power?
Her words, I would say, are the weapon that she has.
Explain that to the jury.
In reviewing the available videos that I had to review, you would see that when Ms. Boone is very stressed, when she's experiencing a high level of anxiety, she becomes short in her tone. You can hear that in her voice. There's a strain, sharper words come out. I think that that is the way that she would try to respond to Mr. Torres. You can hear that sharpness in her voice when she's very stressed out.
Now, would you agree that victims may exhibit a range of behaviors when they're suffering from intimate partner violence?
Yes.
Self-isolation?
Yes.
Suicidal thoughts?
Yes.
Substance abuse?
Yes.
And there are often physical signs of injury such as bruising?
That's correct.
Chronic fatigue?
Yes.
Learned helplessness?
Yes.
Can you tell I know Dr. Brandon spoke on it, but could you tell us a little bit about that?
So learned helplessness is when you start to form the opinion that nothing's going to make any difference. It comes originally from an animal study in which dogs were shocked, and the research study indicated that even when dogs were given an opportunity to escape the environment in which they were being shocked, if they were shocked enough, they just stopped trying to escape. So even though they had an opportunity to do so, they did not do that. That's called learned helplessness. It's the idea or belief that what your actions are going to do are not going to make a difference, so don't try.
What are intrusive memories?
Intrusive memories are an element of post-traumatic stress disorder in which you don't want to be thinking of a traumatic event, but it intrudes on something else you're trying to do. Like maybe you're folding socks or something like that, just doing something mindless, and that's what takes over your thought process. It's not something that you're trying to think about. We could plan what we're thinking about, or sometimes if you're just having this intrusive experience, that's not what you were intending to think about at all.
Is that one of
You know what they're gonna say? You know what Owens is gonna pull? He's gonna say that Sarah Boone, because of her trauma, perceived the hand coming out of the suitcase, which, by the way, wasn't coming out of the suitcase because we all saw the video. It was all zipped up tight, right? So, but, the ghost hand that was coming out and the threat that he uttered when he had no air to utter any threats, and that she can't actually quote, that one, that she perceived in a particular way. And because she couldn't escape. Despite having the phone in her hand and being able to call 911, she called a million times. Oh, she couldn't escape. So her response is to grab the baseball bat. And so this is how they're just going to twist this around to make it fit. So the expert is talking about in general. And the expert is correct in this general description. The defense is trying to make this fit this situation. And honestly, do you think the jury is that stupid? Are they that dumb? Do you think they're going to buy this? Wow, talk about spin.
The conditions that someone may suffer when they have this syndrome, a battered spouse?
Yes.
I know there can be triggers that bring on these memories. Am I correct?
That's correct.
Oh, yeah. And while she's dealing with this, while she has him in the suitcase, she suddenly has intrusive thoughts, a memory of something she didn't like from before. And that's going to explain why she taunted him. So we're just going to tie this up in a sick, twisted little gift and put a bow on it. Come on.
Are there also symptoms of this syndrome where, like in the alcoholism, where you have denial that you're in the middle of this cycle?
Well, as part of the relationship, there's an element of pleasure. Like you have early on in the relationship something that binds you together. So you're remembering that, you're hoping for that, even though the repeated cycle is going through the phases 1, 2, and 3, you keep hoping for elements of that honeymoon phase, wishing that it was better. So it is like denial. You're imagining the way it used to be. You have a recollection of that person showing you positive behaviors, and you're hoping for that. I also think it is typical for victims.
What she just described there is what I call Kodak moments. And I think this is educational for everybody. I think this is an important little point here. Whether it's a toxic relationship or just a bad one, when you leave a relationship, it is common for people to look back and only remember the good things, the hallmark moments or the Kodak moments, that Kodak memory, and they want that back. They want what they thought it was. They want what they wish it was. They want what they hope it was. And this applies whether the relationship was really terrible or not. And so what she's saying is true, but this is human nature. We're still not getting to where any of what Sarah did is justified.
To not reveal to other people that the abuse is going on, and it seems like denial. In other words, your coworkers ask you, are you okay? Did something happen to you? You're not likely to disclose that. That looks a lot like denial. It is a denial in public of some of the private issues that you're having in your relationship. And that's because it's embarrassing. It's revealing a loss of control to other people. It's revealing that things aren't perfect. You might even get feedback that you should leave your partner, and that's unwanted because you're already having that, concern in your own mind about it. And so, it seems like denial on the outside to hide it.
Would you agree many people who suffer from this, they're minimizing what is happening to them?
Yes.
And they're numbing their emotions to it?
Well, to stay present and keep that relationship, it's very difficult for a lot of people because they're experiencing physical and emotional harm. So they want to numb it because numbing it means that you can keep that relatedness no matter how bad it's getting.
Does some people with this syndrome disassociate?
Objection. Relevance.
Approach.
Yeah, that was dangerous ground. Are they going to just try a Letitia Stauch? Disassociation?
Objection to relevance is overruled.
Do you agree that battered women often develop the defense mechanism of being able to psychologically detach from their body during a traumatic experience?
Some people do experience that.
I'm just going to list some of the symptoms that you find in battered spouse women, and just to see if you agree with these. We talked about intrusive memories and flashbacks of the past traumatic events. You agree with that?
Yes.
The severe anxiety and hypervigilance.
Yes.
The panic attacks.
That is sometimes present. It depends on how the person experiences anxiety, but some do have panic attacks.
Very low self-esteem.
Yes.
Poor body image.
Sometimes.
Feeling that they have no control.
Yes.
Sexual dysfunction.
It can be, particularly if the trauma includes sexualized attacks.
Short-term memory problems and confusion.
Yes, that's part of PTSD sometimes.
And they can actually have physical health problems from the chronic stress and physical violence.
That's correct.
Fear.
Yes,
Constant fear.
that's correct.
Now, the abusive partner, the abuser, part of the abuse would be hitting, kicking, punching, choking, burning, and biting.
I'm going to object to relevance.
Approach.
So he's going to list all these symptoms and get her to agree. They're speaking generally about this syndrome. She is correct in what she's saying. The issue here is what I see as a psychological game or tactic, because they're doing it in front of a jury. He's saying all these horrible things, and the expert is saying yes, 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 yes. And it is really easy for the minds of some people to conflate that to mean that it does apply to Sarah, that all these things apply to Sarah. And that's not necessarily the case.
Part, I'm asking about common things that occur by the abusive partner towards the victim that create this intimate partner violence or create this syndrome in the woman. Hitting.
Yes, that could be an overt act.
Kicking.
Yes,
Punching.
yes,
Choking.
yes,
Burning.
yes,
Using weapons to hurt you.
yes,
A knife.
correct.
Curtain rod.
Yes,
Threatening to hurt you, your children, or your pets.
yes,
Belittling and humiliating you.
that's correct.
Taking your car keys.
That would be considered a form of control, so yes,
Controlling your money.
yes,
Control where you go and who you see
correct.
and who you can talk to.
That's right.
Force you to have sex when you don't want to.
Yes,
Stalking you.
yes,
Slapping you.
correct.
Remember, all of this is general, applied to other people. And he's doing this as a game so that the jury hears all this and associates it with Sarah, poor Sarah. It's kind of making me sick.
Do you agree victims that suffer from this abuse experience feelings of anger,
Yes, that can be in some of the phases. So,
sadness,
yes,
hopelessness,
yes,
Anger can be in some of the phases. Do you remember earlier I talked about how she had him in the suitcase and she was angry and vengeful, and how, yes, it's true that survivors will be angry or might be angry, but not like flipping it on and off like that in that moment. And when this expert said, oh, yes, can be in some of the phases, Owens just let's just move along. Doesn't want the jury to hear that part.
Worthlessness.
Correct.
Intense feelings of fear.
Yes.
Abusers have a tendency to have low self-esteem themselves.
Ask Nancy.
Overruled.
Abusers.
Overruled.
The abuser can have low self-esteem himself.
Yes.
Have a desire for power and control.
Correct.
Have a tendency to use alcohol or drugs.
Yes.
Abusers oftentimes have temper,
That's correct.
become jealous easily,
Yes.
very possessive.
Can be.
The victims can suffer from severe psychological distress.
That's correct.
Is that what Sarah Boone suffered from?
Yes.
Yes, sir.
Oh, God. Is he going to show pictures again? We're not hearing from Mr. Torres. You know why?
I'm showing you
Yeah.
Exhibit 14. This is 5 photographs. Did you watch the video of the TV, the Baton TV?
I did.
You considered that in your analysis and your diagnosis?
Yes, I did.
And I'm going to show you some
Did you watch a suitcase video?
pictures.
I can't breathe, babe. I can't breathe.
I believe she's testified that this is where the curtain line. Are you familiar with that?
Yes.
Exhibit 11. Are you familiar with this photograph over here?
Yes.
Exhibit 10, which is her arm. Are you familiar with that photograph?
Yes.
Exhibit 9.
This is a way for him to just get this out there again.
Exhibit 8, picture of her black eye.
Yes, I've seen these.
He's doing this so he
Exhibit
can
7,
repeat
picture
it.
of her, Sarah's lips, and it's like the
I'd be
eyebrow.
objecting to this.
Yes.
And this is a composite exhibit 6, which is of the stab to her leg. Are you familiar with those?
Yes.
And I don't know if you've seen this exhibit 5 is where she spilled some soup as a result of his behavior.
I'm not sure if I've seen this photo, but I've seen a medical record associated with that.
Of that burn.
Yes.
Exhibit 4.
Yes.
Leave with that. Looks like exhibit 3. She was slapped on the tongue.
Yes.
He just told the doctor she was slapped. Like,
In this book.
Yes.
he should
Consider
shut
all
up.
Those photographs informing your opinions that you've expressed here today as it relates to Sarah Boone?
Yes, under the substantiation that she has indeed experienced past instances of intimate partner violence against her.
Is it fair to say that it takes time?
What about her behavior? What about the taunting? Did she not see the suitcase video? Did she not see that?
A number of times to visit with someone like this to build trust.
Yes, traumatized people are slow to disclose information. You have to build rapport. You have to make.
Yes, what she's saying here is true. You do have to build rapport. It is hard for victims to disclose. They tend to not to run all over an apartment complex and tell everybody who will listen that their partner is a horrible guy. They tend to not do that.
Make sure that they experience you discussing other things without an emotional reaction. They feel easily judged, as we mentioned, have defensive denial, things like that. So you need to build good rapport in doing an assessment with somebody that's experienced trauma.
So a lot of times they're very slow to open up and tell you about the abuse.
That is correct.
And they'll actually often lie about it.
Deny it, yes. And just say that that's not the issue or they're fine. So oftentimes I'll have an evaluation request come from an attorney who's having difficulty interacting with their client, and then ultimately it's the result of trauma.
Now, I know that you viewed everything, and I know you've seen her 9 times. Is there any, did you feel like you had enough time? Was 9 visits enough time for you to feel like you had enough time and information to form the opinions that you've expressed here today and given to this group?
Yes.
That's all the questions I have.
Any cross-examination?
Yes, sir. Good afternoon, Dr. Harper.
Good afternoon.
So you have done some evaluation work on battered spouse syndrome for a prosecution in the past?
No.
All right. Have you done insanity evaluations for the prosecution in the past?
I have been called to testify about that.
So you understand when the government obtains a court order for their expert to come in and do an evaluation, it's for one evaluation, correct?
I believe that you're saying that the government can retain their own expert, yes.
No, what I'm talking about is you just went through that you had 9 visits with Ms. Boone, correct?
I did, yes.
And that was over the course of 8 different days because 2 of those visits were morning and afternoon sessions, correct?
That's right.
And what we are trying to help you have the jury understand is that when you get hired by the government and the court gives you an order to go evaluate somebody, you get one crack at the apple. Is that your understanding from your past work working for the government?
No, that's not always correct. There are many instances in competency evaluations where evaluators will request additional visits if they cannot determine their opinion on the first visit.
All right. Specifically when it comes to an affirmative defense, such as battered spouse evidence and insanity, what is your understanding and your expertise?
What is my understanding of the issue? Oh,
Judge, the question...
Legal objection.
Objection?
Legal grounds.
He asked a question about battered spouse and
Approach.
insanity.
Sustained.
Spouse syndrome
Whoops.
being used for self-defense. It comes to an affirmative defense such as battered spouse syndrome being used for self-defense or, not and, insanity. It requires a court order for the state to go have an evaluator go, right?
yes.
All right. Now, what are the agreed upon criteria for battered spouse syndrome?
Well, you would evaluate if the person is indeed suffering from a behavioral response, like a mental disorder. So, first of all, has the person demonstrated that they've got a behavioral change? And is it in response to a violent act? Do they perceive threat where they've been exposed in the past? So, a pattern of violence that has repeated.
Just going to note here that is not what the earlier expert said. The defense's own expert, by the way. So what she is describing, in my understanding, and look, I don't have the degree that she has, so you take it for what it's worth. But what she's describing is a PTSD, right? And the way she's describing it sounds to me more like how you would describe someone if you were formulating a treatment plan and that was the necessity behind the assessment. I'm going to remind you what the expert this morning said was the agreed upon requirements. Remember, the defense's own expert. 1, he said it out really clearly. 1, there has to be abuse, emotional, threat, physical, right? There has to be abuse. 2, because abuse is not enough. 2, there has to be coercive control. So this is a pattern of, having their communications overseen, dictating what they do, financial control, all of that, right? And number 3, the person has to believe that there is no escape. There is no other option for them. So as we go through this, as Mr. J goes through this, I suspect she's not going to be able to set that out so clearly. We'll see what comes out and how it comes out.
Does control over another person in an intimate relationship have anything to do with it?
Yes, it can.
Does isolation have anything to do with it?
Yes.
And by control, I mean controlling who you go see, who you hang out with, so on and so forth?
Yes.
And could it involve controlling personal items of the other person as well?
Yes, it can.
So that's what I'm asking. Like in the DSM-5 TR, I believe you pulled up narcissistic personality disorder.
Yes.
And so when you do that, it pulls up and it says there's 9 criteria and 5 of those criteria must be met to make a diagnosis for narcissistic personality disorder, correct?
That's right.
Now, battered spouse syndrome is not recognized by the DSM-5 TR, correct?
No, it's not a diagnosis. You wouldn't use it as a diagnosis.
And what I'm asking is, even though we haven't written it down in the Diagnostic Statistical Manual, and I mean the, like the Ohio State University or something, is it written down anywhere? Can one psychologist or psychiatrist rely upon a recipe or a list of criteria that everyone else would be using in your field as well?
There is no standardized approach you must follow. In other words, sometimes if we have a statute, for instance, it would identify what we must investigate. It doesn't exist like that. There's no statute directing it.
And there's nothing written down anywhere that says, of these 9 criteria, these things must exist. Controlling your partner, isolating your partner, beating your partner, so on and so forth. Correct?
That's right.
All right. Now, this kind of abuse can come in the form of emotional or mental abuse outside completely of physical or sexual abuse, correct?
So that is a component. You can have extreme mental abuse occur of a person, yes.
And if that person responds to that environmental stimuli of whatever it is the partner is saying or doing to them, they may internally view that as traumatic.
They could.
Or they may not.
That's right.
It's entirely possible for 2 people to be in a 3.5-year relationship that has physical violence and neither one of them feel traumatized by that. Is that correct?
That's right. If they have enough supportive or positive experiences that would negate that ratio, so of positive to negative, they may feel okay.
And a man can be subjected to this sort of trauma, whether it be physical, emotional, or sexual, by an intimate partner as well, correct?
That's right.
And it's basically it's unique to each relationship, right?
That is right.
But trauma is in the eye of the beholder. Is that fair? whether a negative experience traumatizes somebody is going to be in the eye of the person who experienced that stimuli, correct?
I only partially agree with you. It's a complicated answer because some of the manifestations of trauma are behavioral. So for instance, when I evaluate veterans who have returned and they may not know that they've been traumatized, their bodily responses that include like difficulty concentrating, they can't sleep, they're hypervigilant. The PTSD diagnosis encompasses outward manifestations. So even though they don't acknowledge trauma, you can still identify it as a clinician.
But still, somebody like a homicide detective or a homicide prosecutor can go to scenes where there are dead bodies, go to autopsies where there are dead bodies, and not walk away with any trauma, correct? Whereas somebody else might.
Right. The environmental, I guess, cues for that person, and also working with law enforcement, they become seasoned to micro traumas. So almost every police officer can remember the first dead body they've seen. So it's in their memory. And then they become accustomed to seeing gruesome scenes. They have an increased tolerance over time because it's part of their job. It may not be part of their intimate relationship that they have with someone else.
Now, you brought up veterans. Is something common with PTSD with veterans, something like firecrackers may set them off because it reminds them of acts of war?
That's right.
You're not suggesting to the jury today that if somebody who returns with PTSD from service and hears firecrackers is justified in going outside and just shooting bullets everywhere, correct?
No, it's not what I said.
I'm not saying you did.
Okay.
What this battered spouse syndrome evidence is helpful for is not that subjective mindset, but rather helping to explain the objective circumstances that are presented to somebody and how it might be different from somebody with those experiences. They may view something objectively different.
I partially disagree with your question because I would say that there are incidents or actual events between partners that would be a factual thing, something has happened. And then the person subjectively experiences that as, intrusive or controlling or traumatic. So that is the person's felt or subjective experience. The objective part is what happened.
But again, as a forensic psychologist, you're familiar with the justified use of force instruction, correct?
I'm not a lawyer, though, so I'm aware of it, but I cannot debate fine points of that with you. I'm sorry.
I'm just helping. I'm trying to understand what you said before, because there's a subjective component, whether or not a person believes subjectively that they need to use some sort of force, deadly or non-deadly. You agree with that, correct?
I do.
And then there's also a second component that it's objectively reasonable to the ordinary person to use force, correct?
I understand what you're saying, yes.
And what I believe I heard you mention earlier about battered spouse syndrome was originally it was meant to help understand why people stay in these relationships.
Originally, yes.
Because it may not just be intuitive to somebody who doesn't understand these things why somebody who is abused time and time and time again would remain in that relationship, correct?
That's right.
And again, and I know you're not a lawyer, but if the law has evolved about retreat and not having to retreat and so on and so forth, that kind of changes some of the lens of this, correct?
Judge, I'm going to object.
Approach. Check. Question withdrawn. You may proceed.
All right. So you would agree that, hypothetically, if somebody is running down their partner, saying negative things about them, telling them they're unattractive, telling them things that would potentially hurt their feelings, that could be an element of control of a verbally abusive relationship.
It could.
Okay. Propping one up, hypothetically saying, I'm the best thing that has ever happened to you, you'll never do better than me. Is that a potential component of the control that one in an abusive relationship might exert over an intimate partner?
Yes, to try to not encourage their partner to leave them. Yeah.
Considering gifts, hypothetically, that one partner has given to another partner, but considering it still to be your property because you gave it to them, is that a form of potential exertion of control over an intimate partner? When you give somebody, hypothetically, a bike, but still consider it your own bike?
I mean, I don't think that's strong evidence of that. I think that it does happen in relationships and people do that in general, but I wouldn't say that's like really specific to this.
How about hypothetically?
People do that in general. When you give a gift, do you still consider it yours, then that you should still have control over it? Really? Or that you should be able to just take it back at any point? What? And it's interesting, he's asking the same questions as he asked the earlier expert. I strongly suspect that he has these very specific instances that he may be able to introduce later.
Hypothetically exerting control over your intimate partner's identification papers, such as a birth certificate.
So that can happen. People will hide things that are required for work. For instance, like your driver's license or things like that.
Now I'm asking yes or no questions. If Mr. Owens would like you to elaborate further, he's going to have that opportunity in a little bit. Okay. Hypothetically, if one partner destroys another partner's belongings, is that a potential example of exerting control in a relationship?
Yes.
Thank you. Hypothetically, is threatening to or actually using legal process as a threat against your intimate partner in a potential indicia of controlling your partner? For instance, X, Y, or Z, or I'm going to get you arrested.
Yes, I would agree that happens.
Now, I assume you would agree that this cycle of violence that we've described, the tension building, the blow up, and then the honeymoon phase, you would agree that just one of those cycles could be enough to give somebody a traumatic experience if they took it as a traumatic experience.
Yes.
The defendant described her first date with Mr. Torres to you, did she not?
She did.
And at the time of this first date, they had obviously just met that night at a bar, correct?
Right.
They were not financially intertwined, correct?
That's right.
They shared no children in common.
That's right.
They did not live together.
Correct.
And after this description that she provided you, which included him smashing her phone, correct?
Yes.
Hitting her, first time she'd ever been hit in her life, correct?
Yes.
And making her crouch in like a fetal position on the porch for several hours to the point where it hurt her back, correct?
Yes.
Threatened to sodomize her.
Correct.
And she described that she was all bruised up, correct?
Yes.
After that, this is the first time she had ever met him, correct?
I believe so. Yes.
There was a second date, correct?
Yes.
Despite not having any of that intertwinement that we went through prior to this description, correct?
That's right.
Now, it is possible under what we've discussed, right? Just that quick one date can be that buildup of tension and blow up, correct?
Yes.
But it's different, hypothetically, than saying a spouse who is financially dependent on his or her other spouse in a 20-year marriage with a house full of kids than a first date, correct? You would agree in severity, in the intertwinement, there's a difference.
There's a difference in intertwinement. The pattern can be exactly the same.
Now, of course, there are many different reasons why somebody will stay in a relationship that...
Whoa. I just want to point out to everybody, I thought he was going to go further with that. I just want to point out to everybody that while she was on the witness stand, Sarah, giving her testimony, she didn't give this huge description of this terrifying first date. She met him and he was nice and he complimented her and all of that.
When perceived from the outside, others would say is abusive, correct?
That's right.
The defendant described that she felt like she was making Mr. Torres a better person, correct?
That's right.
A better father, correct?
Right.
A better ex-husband?
With phone calls, yes.
And she would tell him to call his children,
That's right.
make sure that he sent them Christmas gifts,
Yes.
and make sure he sent his ex-wife money when she asked, correct?
Yes.
So you would agree those are indicia, or indicators, sorry.
Understand?
I know you knew them. That perhaps she wasn't necessarily financially dependent on Mr. Torres, correct? I'm not saying conclusion, but those are indicators if you're saying, please spend your money elsewhere, that I don't need your money, correct?
No, because even if there was money that was needed by Ms. Boone, her tendency to put the needs of her partner before her would direct her to do exactly that, like make him better, make him have the availability to visit his children, send them presents, even if she's the one that needed the money.
Oh my God. Okay, I'm going to lose it. I'm sorry. I can't not comment on this. And I'm going to sit back from the mic. I'm so mad. So she's like puffing up her ego. I'm the savior. Is this psychologist not recognizing savior complex? I mean, you guys all recognized it. You all recognized it. Holy crikey. And she didn't put him first. She did not do CPR. She was more interested in a smoke and a Dr. Pepper than she was in trying to save his life. I'm sorry. I'm really ticked. I wish I could yell at her. That was what she wanted. Her smoke and her Dr. Pepper. She wants her needs met when she wants, how she wants, and to hell with everybody else. That's who she is. This is Cracker Jacks. Oh, she's putting his needs first. What freaking planet were you on when you came to this conclusion? I am not disrespecting her qualifications. What she's saying about her spouse in general terms is correct. I get it. But wow. I'm sorry. I'm really ticked off. Like she got flippin' snowed.
And in her perspective, Mr. Torres needed her to do this to make him a better person, correct?
I believe that, yes.
How many years of her adult life did she describe working?
I don't think she gave it a specific quantity. We just went through a variety of her jobs that she had in the past.
And, she was low 40s when she met you 4 years ago?
That's right.
So she had been 18 for probably about 24 years. Did she give you a 24, right? 24 plus 18, 42?
Oh, you said for 24 years, and that's why I was confused. You can't be 18 for 24 years, but 24 years ago, I would agree.
Did her work history kind of flesh out to be 24 years is what I'm asking?
I'm not certain.
And at the time, in the apartment in 2020, she had not been working, correct?
That's right.
And had not been working for some time.
That's right.
And what she was doing was living off of the settlement that she had been bought out of with her husband, was lump sum, plus $1,000 a month in alimony and $100 a month in child support, correct?
Yes.
And it was Mr. Torres who would work, correct?
He worked at Ace Hardware, I think.
When he would show up.
Right.
Sometimes he didn't show up, is what she indicated, correct?
Yes.
Because of his drinking problems.
Yes.
Did she describe to you, well, let me strike that. She did describe to you one instance, at least, where violence occurred in front of her child, correct?
Yes.
And that her child had gone to school and reported it, correct?
Yes.
And you understand as a forensic psychologist that teachers are mandatory reporters, correct?
That's right.
Did you review any DCF records in this case?
No, I didn't receive any DCF records.
Did Miss Boone ever indicate to you at any point in time she became too afraid to let Lucas come over to the house?
Yes, there were times where she would ask Mr. Boone, so Brian Boone, to not bring him there.
And Mr. Boone was aware of this because she would say things like that, correct?
Yes,
And at different times, she told you that she would go over to Mr. Boone's house to escape the violence of Mr. Torres.
that's right.
And February 24th of 2020, the child was scheduled to be picked up by Miss Boone, correct?
That's right.
Despite everything that she was aware of and what Mr. Brian Boone was aware of, correct?
Right.
And you saw in her police interview that she swore on the life of her son that she was telling them the truth, correct?
Yes.
Yes?
Object.
Approach.
Why is he objecting? Was in the interview.
I'll rephrase it. She swore on her son's life that it was not intentional that she ended up killing Mr. Torres, correct?
That,
I object.
Approach.
Someone in the chat's asking if an expert's paycheck be contingent on the outcome of the case. No. Not in any jurisdiction that I'm aware of.
And you're not to give them any weight whatsoever. Mr. J, you may proceed.
She's
Questions are... Objection sustained. Question is stricken. Members of the jury, questions are not evidence, and you're not to give them any weight whatsoever. Mr. J, you may proceed.
She's quote unquote swore on her child's life that it was not intentional. That. Correct?
before I answer, I'd like you to direct me to that part of her interview. So
I'll strike it with you. It's on video. Some of Miss Boone's diagnoses predated her relationship with Mr. Torres, correct?
yes,
And so when diagnoses predate a violent intimate partner relationship, there is an independent cause, even though they may then later contribute to the phenomenon we see, correct?
well, I wouldn't say that all mental disorders have an independent cause.
Okay.
Sometimes they're spontaneous or biological in nature.
Well, let's talk about hers. I mean, you're familiar with her prior diagnoses, and you went through her childhood, so on and so forth, correct?
I did.
So she was bringing some things with her prior to Mr. Torres' relationship, correct?
She had these.
Also, yes or no, ma'am?
Yes, she did.
Thank you. You reviewed some Advent health records, correct, of hers?
Yes,
And some Aspire records of hers, correct?
yes,
And you would agree that there are times in the Advent health records where she goes to the hospital and then leaves before getting treated, correct?
yes,
And there is a time when she goes to the hospital where she is described, their words not mine, as having ETOH on board.
yes.
Do you understand what ETOH means?
In a medical record, you would use that shorthand for alcohol.
Or ethanol, right?
Yes,
Drinking alcohol, not the other stuff.
correct.
And in the records that you reviewed from Aspire, she came with complaints of depression in January of 2018, correct?
That's right.
And ethanol or alcohol is a central nervous system depressant, correct?
Yes.
And I know you're a psychologist, not a psychiatrist, so let me know if I'm pushing you too far and you're not going to answer. But you are familiar generally with the effects ethanol has on the body.
Generally, yes,
And you diagnoses of alcohol abuse disorder.
I do.
And in your professional life or personal life, are you familiar with the standard serving size of drinks when you're evaluating somebody's drinking? For instance, hey, I only drink 2 drinks a day. All right, well, are they 64-ounce mugs of beer or are they 12-ounce? So are you familiar in that context?
It might be a question I would ask during evaluation. What are you referring to? Is it a mixed drink? Is it a shot? Like, I try to identify that.
And do you ever ask if somebody says they drink 2 glasses of wine, well, how big are the glasses of wine?
Sometimes.
And is your understanding that 5 ounces is the standard serving of wine since it's about 12% alcohol?
I'm not sure what the standard size is, but I would ask regarding like a wine glass.
And in January of 2018, when she came in crying and complaining of symptoms consistent with depression. She had a blood alcohol level of 0.165, correct?
I believe so.
And in October of 2018, when she ended up going to Aspire, when she was found stumbling by police, she had a breath alcohol of 0.185.
I'm reacting to your description of her stumbling by police. I know she approached police for help. So
she just told me, and probably everybody else, that she actually believes Sarah, and she has now become an advocate rather than an impartial expert.
So there have been two sets of records, but I believe you may have the same set that I received on September 27 of 24. Can you turn to page 21 of 57 of the Aspire records?
mine aren't numbered, but I will.
May I approach the witness?
Yes.
All right, may I approach the witness?
You may.
What I'm showing you is what is page 2157 on records from Aspire that was provided to me by the defense on September 27th of 2024. And just at the top, you can read the first or the fourth lines.
All right, Judge, I would ask that she be allowed to read that entire paragraph under the rule of completeness.
Approach.
No boy. So Mr. J is going to use the defense's own information against them that the defense decided to not use. And now that he's doing that, the defense wants to make sure that things that they might want to get in. So I'm just going to fast forward.
Thank you. All right. In October of 2018, there was a second visit to Aspire, and that was based upon her being found stumbling by law enforcement with a .185, correct? And that's
She
false
walked
reaction?
up. Okay. So I'd have to say no, the way you phrased the question.
Ma'am, Boone was.
Oh boy. So this witness, she's screwing up her own credibility, right? No matter what you thought of her before. But now the witness is going to get defensive because she has gone from becoming an expert witness who is describing the body of knowledge and how it might apply to this case. Now she has become an advocate. So she's going to really take issue with the word stumbling. I suspect that the word stumbling is in a report somewhere. Let's see.
Stumbling due to her level of impairment, paren .185.
Yes, I would agree.
Is that part of the records you relied upon?
Yes.
Thank you. When you talked to Ms. Boone about that, she kind of just described an event of June of 2018 and blurring those two events, did she not?
No, she told me she had 2 different Baker Acts.
Did she describe it as being June of 2018?
I'll have to reference my interview note to find that if you would like me to.
No. Do you remember giving a deposition on October 1st at the state attorney's office downstairs?
I do.
And at that point in time, and I'll ask opposing party, you want me to show her prior statement before I ask her about it?
I think she's got a deposition.
Do you have your transcript?
I do.
Okay.
Just
So for the record, it's page 34 that I'm referring to, line 16 and 17.
Yes, I'm with you.
Okay. She described that as June of 2018.
That's what I said in my deposition, that she was describing her experience in June of 18.
And she described this experience as going to the hospital to find a pastor, correct?
Yes.
And ends up going to what we call Lakeside then and Aspire now, right?
Yes.
And then what you described was she was talking about more of the violence that occurred specifically regarding a significant episode of Jorge driving her roughly in the car, so on and so forth, correct?
Yes.
All right. Those were 2 separate incidences. January when she came looking for the pastor, correct?
So I'm just clarifying that there's a record that we started with this conversation from October of 2018, and there is a description of her trying to go to the hospital to seek a counselor. So those are 2 different instances.
In January of 2018, when she went to the hospital crying and signs of depression,
Bless you.
she indicated that was because her husband and son had gone out of town and she was feeling lonely and sad about having lost her job a few weeks earlier, right?
There were numerous stressors there, yes.
Nothing mentioned about any problems with somebody named Mr. Jorge or George Torres, correct?
You're talking about January?
Yes, ma'am.
Ooh. The other bits of truth start coming out. Pro tip, witness, it's not in there. He wouldn't ask you that. He wouldn't ask you if it's not in there. You see that? The defense presented all this stuff, making it all seem like it was all related to Mr. Torres. And now we find out.
So the hospital records are not referencing her relationship with George on the January date.
I'm sorry. If you go to the hospital with a psychiatric issue, if the concern is the relationship and that is disclosed by the patient, they are going to write that down. They are. So, this answer, well, the hospital records don't reference that. And look here, I just happened to pause it here. Look at the look on her face. Her whole demeanor has changed.
Now, in talking about February 23rd, 2020 with Ms. Boone, you talked to her about that on several occasions, correct?
I did.
And part of one of those conversations, at least, was about an incident that she indicated had happened the night before February 23rd, 2020, correct?
Yes.
And she indicated and told you that she had been dragged down the stairs the night before the suitcase incident, correct?
That's right.
And in part of your review of this case, you reviewed all the crime scene photos, correct?
Yes.
And those include photographs of Miss Boone, correct?
Yes.
And were there any indications in the photographs of injuries on her consistent with being dragged down the stairs of carpet?
I didn't see inside her scalp, so I didn't see photos of inside, her hair follicles.
Didn't see the scalp. That's a redirect on the part of the witness. What about the rug burns that we should have seen on her legs or her knees or her ankles? What about the bruises? What about the... Come on.
In this area of her head. On her outward body, there were no indications of that.
And did you ask her how it was that she was injured during this dragging down the stairs?
I don't think I went through specific injuries to her, no.
No, you just accepted her narrative. Wow.
Do you agree that alcohol intoxication affects the credibility of a historian that's providing history to you, a patient or a client?
If they're actively intoxicated, yes.
We had talked, you and Mr. Owens, had talked about narcissistic personality disorder earlier.
Yes.
And that is a recognized diagnosis in the DSM-5-TR.
That's right.
And there's 9 of those, correct? 9 traits?
Are you you're talking about the criterion of narcissistic personality disorder? Yes.
Might be page 761 on your hard copy.
Thank you. All right.
Was I close? I have a digital copy.
760, but
Okay.
that's
One of the criteria is has a grandiose sense of self-importance, for example, exaggerates achievements and talents, expects to be recognized as superior without commensurate achievements, correct?
yes.
2 is preoccupied with fantasies of unlimited success, power, brilliance, beauty, or ideal love, correct?
Yes.
3, belief that he or she is special and unique and can only be understood by or should associate with other special or high-status people, or institutions, correct?
So 3, just caveat, it says believes, not belief, but the rest of what you said I agree with is the criterion.
4, requires excessive admiration.
Yes.
5, has a sense of entitlement, unreasonable expectations of especially favorable treatment or automatic compliance with his or her expectations, correct?
Yes.
6, is interpersonally exploitive, takes advantage of others to achieve his or her own ends, correct?
Is interpersonally exploitative. I agree.
What the crap? What the crap? The jury knows what it means. Let's just correct Mr. J. Is she Sarah's, long-lost sister or something? Is she going to pull out Webster's dictionary too any second? I'm sorry, I'm being silly, but I'm irritated. I just need to be snarky.
7, lacks empathy, is unwilling to recognize or identify with the feelings and needs of others, correct?
Yes.
8, is often envious of others or believes that others are envious of him or her, correct?
Yes.
9, shows arrogant or haughty behaviors or attitudes.
Yes.
Now, you believe that she has traits of that disorder, correct?
Yes.
Grandiose sense of self-importance?
There are indications that she feels like that or has expressed that before.
So that's a yes.
Yes.
Preoccupied with fantasies of unlimited success, power, brilliance, beauty, or ideal love?
No.
You remember going to the state attorney's office on October 1st of 2024 and giving a deposition?
I do.
And it was in front of a court reporter like Madam Court Reporter here?
Yes.
And you swore to tell the truth, the whole truth, and nothing but the truth, correct?
Yes.
And referring to page 89, lines 18 through 20. Let me know when you're ready. Are you ready?
Yes.
Did you give the following answer to the following question? Preoccupied with fantasies of unlimited success, power, brilliance, beauty, or ideal love? And your answer was yes?
I did answer yes there.
Whoops.
She does not, according, in your estimation, does not believe that she is special and unique and can only associate with high-status people, correct?
No.
Does not require excessive admiration, correct?
Correct.
Does have a sense of entitlement?
Yes.
Is not interpersonally exploitive?
Correct. She is not.
What? What? Not interpersonally exploitive, or is it exploitative? Not calling Brian, give me money, order me bucks, and if he doesn't comply, she's, writing to the judge. She's abusing me. Oh my gosh. Not dragging that neighbor in who has a disability and didn't know anything, like dragging her in to testify because nobody else flipping would. Going around the neighborhood asking people for things, right? Not exploitive, not at all. Oh my gosh.
And when discussing whether or not she lacked empathy or was unwilling to recognize or identify with the feelings or needs of others, you indicated that that might be the case, but it's not intentional.
In other words, she's not aware she's inconveniencing others.
So there was 3 of those traits, correct?
Yes.
Not 5, which would be required, correct? For a diagnosis of the personality disorder.
If that were the correct diagnosis, you would need 5.
All right. During your conversations with Ms. Boone, the defendant in this case, she explained to you that cheating to her means when Mr. Torres would look at pornography, correct?
Correct.
Not a real-life woman, right?
No, not that he was engaging in sexual intercourse with actual women.
Part of the records that you did not review were the text messages that were part of the phone extraction of her phone device, correct?
That's right.
You indicated in your conversation with Mr. Owens that some of the traits that are commonly seen in abusers would be control, jealousy, easily angered.
Those could be, yes.
What other traits just common for abusers?
Being a person who segregates their victim away from other sources of support, somebody that exhibits coercive control, meaning that they would prevent the person from engaging in activities that would be independent, so restricting their ability to have independent, like life, job, money, things like that, that would be supportive of them being left, for instance. Other things would be using emotional expressions like rage to cause a physiological reaction in another person. So those could be additional descriptions.
Do you think she's even aware she is describing Sarah? Oh, wait. It's unintentional. She's unintentionally describing Sarah.
Specifically, the materials you reviewed. I just want to make sure we're on the same page. Paperwork from prior cases involving Mr. Torres and Ms. Boone.
Yes,
Medical records for Mr. Torres.
that's right.
The medical and Aspire records for Ms. Boone that we've discussed.
Yes,
The crime scene photos from the incident in February.
that's right.
Pages 1 through 413 in discovery in this case.
Right.
A photograph of a suitcase and 2 videos involving a suitcase.
That's right.
And additional videos on that phone, correct?
Yes,
Such as baseball bat smashing the TV.
that's part of it. Yes.
And then did you review any other videos where there's conversations between Ms. Boone and Mr. Torres?
Yes.
One prior 911 call?
Yes.
Now today you had indicated that you had reviewed the photographs from some prior incidents of violence, correct?
Yes.
When is it that you did that? Was that recently?
No, there are photos included with the
The prior case packages?
case packages. Thank you. I'm not sure what to call it. So
That's fine.
Right.
All right. And did you review any body-worn camera from those prior case packages?
no, I did not. I didn't have that.
Anything else that you reviewed that I've not covered?
Are you speaking of documents only?
Yes. Materials other than your 9 visits with Ms. Boone.
All right. Just checking with the
That's fine.
folders I prepared
I just
for
wanna make
today.
Yeah, she knows she's incredible.
I don't know if, I guess that would be part of the discovery. The investigative report is within those 413 pages.
Okay. Did you interview anybody else personally besides Ms. Boone?
Yes.
Who else did you personally interview?
Melissa Sexton?
All right. Anybody else?
No,
You didn't interview Brian Boone, correct?
I did not.
You did not interview their child in common, correct?
No,
And you didn't review the phone text messages extracted from her device, correct?
no, I didn't.
Did you review any records from the jail?
No,
And
Judge,
Yes.
Owens is like, I'm tired. I'm tired. Can you quit doing this? I don't like it. I'm tired. Can we move it along? We move it along when Jay is talking, not when I'm talking. I'm just fast forwarding here, guys. I think it just blows my mind that anyone can see that suitcase video, and I don't know. This is pretty twisted. The GC is saying, stop the bleeding. Brian was giving her child support because he had to. Right. Captain Katie, no collateral info from anyone who knows Sarah. Yes, that would have been really important information. Fast forwarding still. Wow. Oh, thanks, Rel. I'll check my email. Somebody's saying the expert is exhibiting signs.
The
of
objection
shame.
is sustained in part and overruled in part.
you testified earlier.
Oops. I pushed the wrong button. I'm getting tired.
In the normal course of practice of forensic psychology and psychiatry, you all do rely upon the diagnoses of other experts, correct?
You can inform my opinion, yes.
And you have not reviewed any electronic communications in the form of text regarding Ms. Boone's case, correct?
No, I did not.
Or recorded phone calls of any type, correct?
Well, 911.
Other than that.
No, other than that.
Now, let's talk about the February 23rd of 2020. She told you that they didn't really have anything going on to do that particular day, correct?
Yes.
It was a Sunday, correct?
Yes.
Did some chores, and then as a reward, they could rest after doing those chores, correct?
Right.
She indicated to you that she and Mr. Torres did not begin drinking till about 4 p.m., correct?
I'll have to reference.
Page 36 of your deposition, if you care to use that.
Great, thank you. 36?
Yes, ma'am.
If Sarah said they didn't start drinking till 4, then, I mean, they finished a leftover bottle, according to Sarah, from the night before, which was that 1.5 liter sized bottle. So it was quite a bit already. They went to Publix at noon. So is she saying that starting at 4, they consumed all of that before George went to Publix again? Is that the story? Wow.
All right, I'm with you. Around 4 p.m.
And you reviewed the crime scene photos of this case, correct?
I did.
That included receipts for some purchases that were made at Publix on February 22nd and 23rd, correct?
That's right.
And one of those receipts was a purchase for a 1.5 liter bottle of Woodbridge Chardonnay at 12:17 p.m. on February 23rd, correct?
Yes.
Did you question her about the inconsistency of them having purchased a bottle of wine at 12:17 that afternoon and not start drinking until 4 p.m.?
No.
And did she tell you that they had any wine left over from the day before that they consumed that day?
At some point, I'm not sure if it was the day that I was going through this line by line with you in my deposition, but I am aware, yes, that there was an unfinished bottle of wine from some other date.
And then, as the receipt showed, there was 2 additional bottles of 1.5 liters of wine purchased at 12:17 p.m. and about 5:30 p.m. on the 23rd, correct?
Right.
And were you aware of approximately how much Ms. Boone, the defendant, weighed at the time of this offense, February 23rd, 2020?
Around 100 pounds.
And in the first 413 pages of discovery, I believe, was the autopsy report, correct?
Right.
And so you're aware that Mr. Torres was 103 pounds at his death?
Yes.
Do you take into account this alcohol consumption when evaluating what Ms. Boone is telling you about the events of the day?
Yes.
Did she tell you whether or not she was intoxicated by the amount of alcohol she consumed that day?
Please silence your cell phone.
Okay.
You may proceed.
So she did not describe herself as intoxicated originally when we discussed this. So
So the answer is no. She did not describe herself as intoxicated.
intoxicated, right?
Therefore, if you believed her and did not check her story and did not compare that with all the evidence, right? That's why that whole body of evidence is important. And you continued your assessment under the impression that she was sober, that changes things. Any assessment is only as good as the information that the assessor has.
Hypothetically, if she had told the jury that she was intoxicated at the time of the offense, would that affect your evaluation of her credibility in the history she provided you?
No, because that was also my opinion.
Did she indicate to you in describing the events of February 23rd, 2020, that there was any point in time she just simply did not remember?
Yes.
And what points in time were those?
So she did not remember taking the videos of the suitcase, or the incident in the suitcase, until she was at the interrogation room, I guess, and then.
So, here's the thing with I don't remember, whether it's a blackout, whether it's true, whether it's not true. She doesn't remember either video, despite the fact that they were minutes apart, does not remember the suitcase incident, doesn't remember taking the video. How then, pray tell me, does she remember the 11 minutes between the two videos in such detail? And she's fearing for her life and where she left the zipper and all that jazz. How does that work?
They were going through them with her, and she recalled that.
I'm talking about specifically with you. Did she indicate that there were any portions of the night or day or night that she did not remember?
I can't recall anything specifically right now.
Hypothetically, if she had indicated to the jury that she did not remember the 9 or 10 minutes immediately preceding the first video being taken, would that be inconsistent with what she told you then?
No.
Well, she didn't indicate to you that she forgot any part of the night, right?
Right, she just didn't say that, so.
Would it affect your evaluation of what she told you about the events of February 23rd, 2020, if she hypothetically has testified that she did not remember 10 minutes before the videos?
Not really, no, because the event and the course of events that she narrated to me occurred over several hours. So when you interview somebody about circumstances of an offense, it's the usual for someone to not remember every single minute for hours at a time. I can't imagine that anybody's memory could hold that much unless they have like photographic memory or something.
This is crap. This is crap. It's bugging me. Okay. It is true that witnesses do not remember every single detail. Sometimes witnesses just blah, 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 tell their story and they leave out a whole bunch of details. And when they're settled down, the adrenaline is down, they go, oh yeah, I should have told them this, that, and the other thing. And that's why officers say to you, if you remember anything else, give me a call. But what witnesses do remember are things that create emotional impact. Can't tell you how many times I've gone to a call where, say, there's a robbery or something, and the witnesses can't tell you what time it was, what the bad guy was wearing, what else was going on at the scene, but they can tell you in great detail what the weapon looked like because they're hyper focused on that, and that is the thing that causes the emotional impact. Or the moment in a home invasion where the patio windows crash in, they remember emotional events. So if this is just a normal lapse in memory, then it's the suitcase bit is not the part she's going to forget. And if she truly forgot about that and before and after. She cannot claim anything. She can't claim what she did or didn't do because she doesn't remember by her own words. So she did or she didn't. She wants to change it to suit herself. So this is crap, and I don't like the way this expert is basically trying to cover. Just tell the truth about the body of knowledge in the field. Just say it.
I'm not asking about hours and hours of, an itemization of her day's events. We're talking about the 20 minutes of the offense. Does that affect the weight that you give her history she provided you? It's just yes or no.
No.
If you're assessing anyone, whether it's a psych assessment, a medical assessment, or a threat assessment, and I'm sure many others, if the client tells you, I'm missing a big chunk of memory, isn't it logical, even to those of you who don't do assessments at all, isn't it a logical question to then start to delve into, oh, what else don't you remember? What other time? When was the first time? What's the first thing you remember? What's the last thing you remember, et cetera, et cetera? And how often has this happened before? It should have changed her assessment. She's lost me.
Now, what she indicated to you was the day had been going well. It was fun and games, correct?
Yes.
Conflict-free?
To her, she said it was a good day. So
Okay.
that's what she told me.
She said it was a good day.
Yes.
And there comes a point in time where the activities turn toward hide and seek, correct?
Yes.
And she goes up to the shower,
Right.
and when she comes down from the shower, that's when Mr. Torres is in this suitcase, correct?
Getting into it.
And she goes over to the suitcase and zips it, correct?
Yes.
And did she describe whether it was 100% zipped to you or just a certain percentage?
She said that it wasn't zipped all the way.
Okay. And still then, that was funny to the two of them at first, correct?
That's right.
And then there came a point in time where Mr. Torres was getting mad about being zipped in the suitcase.
She told me that he was getting mad. Yes.
And that, in turn, made her mad.
That's right.
What Mr. Torres was saying was, I can't breathe, correct?
That is what's recorded on the video.
Well, I'm asking you about what you reported her saying.
Well, what made her mad was not that he was saying he couldn't breathe. It's what he was saying that was making her mad.
Well, what else was he saying?
At the time, she said that he said something that was making her mad. And so that's the extent of what we talked about at that moment.
So you didn't elaborate what something was that made her mad, correct?
Right. She said he said something that made her mad, and that started making her mad.
You didn't find it important to learn what specifically he said that made her mad, correct?
I don't agree that I didn't find it important
Okay. Then explain. Why wouldn't you ask that question?
because as a person who is traumatized is describing their experience as a trained.
She's not there to provide treatment. What she's starting into here is how you would respond if you were treating someone. This is an assessment. They're two different animals. I am so not impressed.
Clinician, you will allow open-ended discussion of that experience. And so it's not an interrogation. You don't go asking confrontational questions at the time of their first narration.
Well, you had 9 visits with her. Did you follow up on your 9th visit?
I asked her different questions about
Did you ever ask
be
her?
confrontational.
Did you ever ask her specifically in any of your 9 visits with her what it was that he said that made her mad?
No.
She never described him doing anything to make her mad, but it was words, correct?
Right.
And once she got mad, she decided that she was going to leave him in there for 2 minutes.
That's right.
Not 3, not 1, but 2, correct?
That's what she said.
And the reason she was doing that was because she wanted him to understand how it feels to be choked and what she had experienced.
That's right.
Just a reminder, because we keep hearing this is all Sarah's narrative, Sarah's version. Mr. Torres can't speak for himself. What Sarah did, this is how I feel. I'm going to make you suffer. I'm going to make you squirm. I'm going to make you feel this. I am intentionally leaving you in here. That is called revenge. That is not fear.
Did you ask her why she didn't let him out of the suitcase after 2 minutes?
Yes, I did actually ask her that.
And what did she say?
Well, she thought that he could get out himself. That's one thing. She said that when she was able to unzip it, it was not some significant thing. She was able to unzip it easily. So she said it never occurred to her that he couldn't get out.
You may proceed.
And you reviewed the still photograph of the suitcase as well as the 2 videos.
Right.
And did you understand what the metadata or what the timestamps were for each of those items?
I'm sure when I reviewed it, I saw the timestamp. Yeah.
Would you agree that 20 minutes is 10 times as long as 2 minutes?
I would.
And if Mr. Torres had not been able to get himself out of the suitcase within 20 minutes, she didn't indicate that she let him out, correct?
She did not.
She described to you, Miss Boone being the she, that she was helpful to the police.
Yes.
Do you agree with that assessment that she was helpful to the police?
In the sense that she was having conversations with them without counsel, I would consider that helpful to the police.
You know what's coming, right? Do you think that lying to the police is being helpful?
Do you think lying to the police is helpful to the police's investigation?
No.
Do you agree that she was not truthful with them?
Yes, I think that I would agree with that.
And when she described getting Mr. Torres out of the suitcase, she described stretching his little legs?
Yes.
And she stated to you there was no fight that day, correct?
That's right.
Just wanted him to be uncomfortable.
I need to clarify. Physical fight.
Right.
Yes.
Just wanted him to be uncomfortable,
Yes.
correct? And then there was a description of a bat and her using it to nudge, right?
Poke.
Poke. And so, do we agree that that means like poking out like this as opposed to swinging it like you're a baseball hitter?
I would agree with you.
And you reviewed the autopsy report, correct?
I believe so.
Did you get an opportunity to review the autopsy photos?
Yes.
Did you question her when she said that she only poked him with the bat?
No.
Not in any of your 9 visits?
Did I question her about whether? Can you just repeat the question? I want to make sure I'm answering it correctly.
Yes, ma'am.
Okay.
Did you ever, in considering the autopsy report and the autopsy photographs that you reviewed,
Yes.
when she said that she nudged or poked with the baseball bat, did you ever question her about that, given the severity of his injuries?
So to answer correctly, I did question her
What did she say?
about how she used the bat.
Okay.
And she reiterated that she poked and she gestured what she meant. So I did question her about that.
And did you?
But the question, ma'am, is were you questioning the credibility of that, considering the severity of the injuries on the victim? And it sounds like she didn't, and she's trying to skate around that.
You have any questions about that history she relayed to you, given the other evidence in this case that you reviewed?
Just in contrast to the interrogation video. So that.
You don't, it didn't contrast to the autopsy photographs or report?
Judge, I object.
Roach.
Oh boy. We're going to fast forward.
Did she indicate all this nudging or poking with the bat was done while he was inside the suitcase?
Yes.
She never told you that there was any nudging or poking with the bat when he was outside the suitcase?
Correct.
She indicated that she ended up flipping the suitcase over face down?
That's right.
Did she tell you about Mr. Torres calling his brother earlier that evening?
No.
Did she ever give you a history about a loud boom occurring inside of her townhouse that evening?
No.
And you never had the opportunity, obviously, to interview Mr. Torres about these things, correct?
Of course not. No.
No other questions?
Any redirect examination?
Briefly, Judge.
Yes, sir.
The state attorney talked to you about power and control, that an abusive partner will use power and control over the victim in a intimate partner violence situation.
Yes.
Threatening someone's dogs, is that an example of someone using control?
Yes.
Taking car keys from the other party, is that an example of control?
If they're withholding, yes.
Taking a phone and withholding a phone,
Yes.
a debit card,
Yes.
destroying a home, TVs, putting holes in the wall,
Yes.
not helping pay the rent and other bills.
So I would say that that could be withholding, that could go under coercive control of another person.
What about violating a court order to have no contact with the person?
Yes.
That's all the questions.
Thank you. Can this witness be released?
If all you had was what Owen just described and the evidence that supports what he just described, if that's all you had, you would think Mr. Torres was this horrendous, crazy stalker dude, except everything he said, or almost everything, because it wasn't everything. Almost everything he said is Sarah's narrative and Sarah's characterizations. And once again, as is common in the Sarah Boone circus, really important facts get left out. So there's that.
As far as the state is concerned,
Mr. Owens? Thank you, doctor.
Thank you. Just allow me a moment to pack up.
Collect all your stuff, ma'am. No worries.
Sorry.
No apologies necessary.
Try and fast forward.
Yes.
William is asking, is any of this aside the TV substantiated? Well, first of all, the whole TV thing, there's some question as to how one might characterize that. If that was a fun thing that was sort of turned around. Yes, some of it is substantiated.
All right, members of the jury, it is.
Yes, he did get in trouble for violating a restraining order. There was a time when Sarah wanted him back. It's not like he went and broke down the door, right? Sarah wanted him back and got mad at him because he took her credit card or debit card and went to the store or something, and she was mad at him for it. So she called the cops on him and was shocked when he was taken away because he'd violated the no contact order. See, she wanted him there. So she couldn't control the system as much as she thought she could. So yes, some of it is substantiated and some of it is a lot of game playing. I hope that answers your question. Linda says, if someone loved their dogs as much as Sarah claims and somebody hurt the dogs, would that person still be in your house? And if you're in a situation where you are cohabitating with them and you can't get out, you can't leave, then yeah, you might stay. Some victims stay because they're afraid if they leave that their pets will be harmed and they can't take the pets with them. However, in this circumstance, she had no problem throwing him out whenever she wanted. And if he didn't leave or she didn't want to have the confrontation, she just called the cops and have the cops throw him out. So there was no issue there with her being unable to leave or being unable to get rid of him. And, where are the receipts? Where are the vet bills? She cared so much about her dogs that, they're smashing this TV and letting there be glass on the floor. Cared so much about her dogs that they have these huge fights and the dogs are barking, and how stressful is that? Cared so much about her dogs that even at the crime scene, she just let them be running around, right? Cared so much about the dogs that the officers actually had to take care of them. And when she left that day, she didn't bother to feed those dogs that she cared so much about. So you tell me, I don't know. And how she's saying he loves the dogs. This story is new, so it's all nonsense. Yeah. And they hadn't been out, right? I'm just going to fast forward and make sure that we're not missing a motion or some darn thing. Okay, I think they're done for the day. Oh, maybe not. Let's see what this is.
Yes, sir.
Yes. Judge, there's two orders that I'm going to be requesting the court to take judicial notice under 90.202 sub 6, and the orders are no contact. I have copies of the certified copies of the orders. May I approach?
Yes. State, have you seen them?
Doesn't change my position.
Understand, but you have seen them.
I have not.
You have not seen them. Okay.
Doesn't change my position.
Understood. Okay. You can bring them on up. Thank you, sir. Court has been provided no contact orders issued in case number 2019 MM5062 on or about June 16, 2019, and a no contact order in case number 2019 MM5114 issued on or about June 19, 2019. Both cases styled State of Florida versus Torres George Jr. Let me hear any argument as to the judicial notice from you, Mr. Henderson.
Judge, I think they're relevant. I think just from the testimony of redirect of Dr. Harper saying that an element of control. And control is talked about greatly by the state. When I point out things hypothetically that they refer to. They refer to them as hypothetically. However, they refer to things that they're developing on this Boone. These show that there were in fact orders, and the orders were for no contact. So these are elements of control in relation to George Torres.
Okay. Response.
So in regards to the judicial notice aspect, we don't dispute that that can be a substitute for authenticity. However, they're not relevant, they're not admissible. They contain statements that were made by people who are not testifying. Just because an expert relies on something doesn't mean that it's admissible. What happened during redirect with Mr. Owens was he was asking, what are the hypothetical things that we rely upon in making these determinations as an expert about whether there's staggered spouse syndrome or not. So one of the many inadmissible things that he mentioned was pretrial orders of no contact. So it's fine. The expert can certainly rely on the fact that there may have been pretrial contact orders or no contact orders that were involved in this case, and she considered that. That doesn't make them admissible. There has been testimony, I believe, from Ms. Boone that there was pretrial no contact orders and violations of them. It's not a fact in dispute. It's just that doesn't mean that the paperwork comes in as evidence. So that's our objection, is it's irrelevant and hearsay. Just because an expert relies on inadmissible evidence doesn't make it admissible.
What's your response to hearsay?
Judge, I think under the, as to hearsay, I think the statute takes care of that itself, because it says that the court can take judicial notice. So that's the foundationary part. And it's not hearsay. It's an order of the court. We're in a case where we've gotten evidence of past domestic abuse. There was evidence started with the state about control. And these are things of control. And I'm sure the state's going to, in rebuttal, they're going to come up with things that they feel either by body cam or any other evidence that shows her exercising control. This shows Mr. Torres exercising control. It is very relevant.
I think this could be a can of worms, because then the prosecution would have to get into why and how the violation of the order happened. It's just going to drag things out. I think this is cumulative. I don't know. I'm suspecting the judge will let it happen.
But how's it not hearsay? Just because it's a court record, it's still out of court statement. It's certainly being offered for the truth of the matter asserted. No contact order.
Judge, that's why we have the thing that the court could take judicial notice of. There are certain things that court...
But the case law says you can't utilize judicial notice to get around hearsay. I know 9202 says that I may take judicial notice. 9203 says that upon sufficient notice being provided, which the state is conceding based on their argument, the court shall take judicial notice of items identified in 9202. But my question is, the case law, as identified in Professor Earhart's treatise, specifically says in Dufour v. State, 69 7th 3rd, 235, which specifically talks about notice of judicial documents in a court file, that doesn't get you around hearsay. So what's your response?
Let me go through hearsay in my mind again.
You're fine. Take your time.
I have to think about it, Judge. I don't know that this is really worth fighting about, is it? For the defense side. It is for the prosecution.
Judge,
Yes.
I'll start this way first. One of the exceptions to the hearsay rule is business records exception. So if it's a business record and it's kept in the normal course of business, then someone can come in and lay the foundational things for the business record exceptions to the hearsay rule. However, in this case, that would not be needed if the court takes judicial notice of it. That eliminates the necessity to do a business record in that foundation, because the court, under the statute 90.2026, can take judicial notice of court orders. This is a court order. It's certified. I think it's an exception to the hearsay rule. Also,
This is hilarious. So he starts out with almost like a threat. Look, if you don't give me what I want, take the notice, then I'm going to try and go about this the other way. It's going to be a pain in the butt. So I'm not going to do that, Judge. And you have discretion, Judge. After the judge just pointed out, yeah, I have discretion, but you can't use that to get around the hearsay rule. So far he hasn't actually cited something that would directly rebut the judge's argument.
I think the probative value of these documents outweighs any prejudicial effect.
Any other argument?
No, Your Honor.
Any other argument, State?
The fact that there was a pretrial court order of no contact between them is going to come in. I mean, on one of the body-worn cameras, Mr. Torres is like, well, you know, the court said I couldn't, but she said I could come. And I believe she testified to that during her examination. My objection is to the paper and the grounds that I've argued.
Okay. All right. Thank you very much. State v. Mobley, 98 Southern 3rd, 124 by the Florida 5th District Court of Appeal, cited in 2012, says that there's a procedure that specifically needs to be followed for judicial notice, as set forth in 9202 and 9203. State is conceding that although there's not a writing, they're not objecting to the judicial notice concept. They're objecting to the evidentiary bases. I do find that it is relevant, but the problem is I have with hearsay. And the court, in relying on the Florida Supreme Court decision in Dufour, D-U-F-O-U-R v. State, 69 Southern 3rd, 235 at pinpoint 253 by the Florida Supreme Court in 2011, which states, while the court may take judicial notice of documents in a court file which were properly placed there, this notice would not make the contents of the documents admissible if they were subject to challenge, such as when a document is protected by privilege or constitutes hearsay. It is an out-of-court statement that is being offered for the truth, to wit, it is a no-contact order, and the requisite requirements for a business record under 98036 subsection A have not been met, nor has there been a certificate from the custodian of records as to those things, as required by section 6, paragraph C, and the timeliness of a certification. So I cannot accept judicial notice of these two documents, even though the state is not conceding the procedure for judicial notice. I am sustaining the state's objection as to hearsay under the grounds and the exceptions that you have offered.
Judge, we do have the clerk of court subpoenaed. I don't know where they are. I assume they're somewhere in this building. I believe they sent some message to us back before the hurricane about what they needed were to come, and we said to be continued. So we haven't gotten back up with them yet. So it would take me some time to check on that. It's 4:30.
Was the subpoena still for this time period?
Yes, I believe it was a 3-week period.
Okay.
But we haven't followed back up with them. This came up
Sure.
late.
I'll give you an opportunity to do that.
I don't know whether you could just go ahead and send them to home for the evening, and let me see if we could find the clerk maybe in the morning, and then we could rest in the morning, and then the state has Dr. Werner. It's probably going to take me a little bit to find.
I'll give you that opportunity. Absolutely.
Right now?
If you want to, sure. If you want to try to do it now or do it tomorrow, I'll leave it to you. Because I can't imagine it would take long if we're able to get a records custodian or a person to lay the foundation. I can't imagine it would take that long.
Aren't they in the building?
Yes. Third floor?
Could y'all go?
Sure.
I suggest we go ahead and let the jury go. It's 4:30.
Okay.
I don't know how long it's going to take to do that, but we could present that in the morning and then rest in the morning and then they can.
All right, that works for me.
I'm not going to make some poor employee come in and do that. I was conceding the authenticity. I just don't understand the relevance of it coming in.
Are you now withdrawing your hearsay objection?
Well, I still believe it's hearsay, but I think it's cured by it's a public record and it's stamped and all that stuff.
I know, but no one's made that argument yet.
I don't want to punish some poor clerk.
Okay.
No, being nice
I
is.
won't object to them coming in.
No!
But it's a slippery slope for other records. We'll see what we do as well.
Okay. All right. So.
Because he's a nice guy. And Owens doesn't give a rip. So Owens wins this when he shouldn't have. I'm irritated. Yikes. I think I know the legal objection is hearsay, but honestly, I think it opens a can of worms, and I think it's just Owens sort of bashing the jury over the head with pieces of information and not the whole story. And he's going to have this official looking thing, so it's going to sound like Sarah is more credible than she actually is. So yeah, I don't like this.
So the state is still maintaining its hearsay objection. I do find that it is relevant.
But I don't want to make my clerk come in.
So then what do you want to do, Mr. J?
I'm stipulating to if the hang up for the court and the defendant is that they believe a clerk in the court needs to come in and testify, I'm conceding that issue so that person does not have to do whatever that issue is.
Okay. All right. Fine. Then, based on the court on the concession by the defense, by the state. Excuse me. Do you have any other objections with regard to these two non-contact orders, Mr. J?
No more objections.
Okay. For the reasons previously articulated, I do find it's relevant. The state has withdrawn its hearsay objection. Do you want these as a composite or individual?
Individually.
Okay. Madam Clerk, could you pre-mark them and then we'll identify them, please?
I hope they play the whole body cam video then. And I hope that they get in that she was wanting him to be there. It's not like he was a stalker. I hope they make that clear. This is bothering me. I'm going to try and fast forward.
The cocaine is dated as AC. 11 is AB. And the no contact order in 19 MM 5114 dated June 19th, 2019 is dated as AC. Mr. Owens, you can approach. Let's just tackle a couple other housekeeping matters that we have. You can move those in when our jury returns into evidence. Are there any other witnesses, evidence, or testimony, sir, that you're going to be offering this afternoon?
I don't believe so, but we're intending on resting either this afternoon or first thing in the morning, but we want some time to talk to Sarah Boone and explain to her why we think we should rest, not call any further witnesses, not introduce any other exhibits, just to make sure that we're all on the same page with her about what our strategy is. So we need a little bit of time. I don't know if you want to go ahead and excuse the jury for the night and then have us come back in the morning and do that colloquy with the court, with the defendant. But we do need some time with her.
Okay. All right, so then here's what we'll do. I'll bring in the jury and I'll excuse them. You can save those pieces of paper and you can move them into evidence tomorrow morning and then present. That'll work.
As long as they're chatting. Thank you.
Thank you, Madam Clerk. We'll bring the jury back at 9 a.m. tomorrow and you can continue with your evidence presentation at that time, including but not limited to calling any additional witnesses. Court can have any further colloquy with the defense at that time. The state then can put on its rebuttal case. The state, how long do you anticipate ballparking it for the court, your rebuttal case?
I don't believe Dr. Werner will take long on our part. I'm not sure how long it will take on their part. And then there's about...
How long is that for your part?
I'm not going to hold you to it, Mr. J.
Probably less than 30.
How long do you anticipate your cross being? And ballpark it. Again, I won't hold you to it.
If his direct is 30, my cross is probably going to be 30.
Okay, what else do you have to present?
And then there will be about 2 hours of videos from body-worn camera and from the phone extraction.
Mm-hmm.
And then reading a good bit of phone text messages with the record.
Separate and apart from the 2-hour video presentation. Okay, got it. All right. Okay, so that's going to take us in tomorrow afternoon. Are we going to be in a position for the state to rest its rebuttal case tomorrow and proceed with closings, or are we going to proceed with closings Friday morning after had the opportunity to have a full, not that we would not have a full charging conference, but after having a charging conference Thursday afternoon with regard to the jury instructions?
I just don't know how long. I think all the instructions are pretty relatively simple and straightforward, except for 3.6.
Agreed. 3.6F. I agree.
That's not going to be simple or straightforward in any way.
The instruction is complicated. I agree.
And the special jury instruction on our spouse that we're going to be requesting.
Okay.
There's different courts, Judge, here in Florida that have used the special instructions. There's different courts in other states that have used a different instruction. We've looked at a bunch of them, so I don't know what this court is going to be inclined to do if court would be so inclined to give a special instruction on battered spouse, and whether or not you want to consider one of the local courts, the Palm Beach County case that I mentioned before with Dr. Brennan. There was a special instruction in that case. And then we've got some from other states. I don't know what the state's position is going to be on that. So we may...
Has a draft of that been circulated yet?
Not to the court.
Okay. All right. All right. So here's what we're going to do. Okay. Let's just see how long the rebuttal case takes. And then if we have to do closings Friday morning, we'll have to do closings Friday morning. I'd rather go through and spend the time to make sure that we're all on the same page with regard to the instructions, especially due to the complicated nature of 3.6F. With regard to those, the court will have Ms. Barrios email you all. She just started her drive back to Kissimmee, so it might come a little bit later this evening. I will have Ms. Barrios email to you all the red line that the court has worked on so far of the jury instructions provided by the state. The defense is to provide its markup of the 3.6F and 3.6G instructions and any other defensive instructions that the defense seeks to have read to the jury.
Before 9 o'clock in the morning?
I think so. That gives the state the opportunity during the lunch hour to review them in advance of our charging conference.
I'll have it done before 9.
Okay.
Judge?
Yes, sir.
There was one thing. The state had filed a motion requesting a special instruction as to, I think it goes to voluntariness. I read the motion and the proposed instruction. I have no objection to it.
Okay. All right. So just so the record's clear, we're referring to the state's request for special jury instruction regarding Florida Criminal Standard Jury Instruction 3.9B, defendant's statements filed October 22, 2024. The provision that the state seeks to add to the 3.9B instruction reads as follows: law enforcement is not legally required to ask a suspect whether he or she wants to talk to law enforcement after Miranda warnings are read to a suspect. This is, however, one of the factors you may consider whether the defendant's statements were voluntarily made. The state, state, have I read that correctly?
I believe so, without reading myself.
And defense, you have no objection.
No objection, Judge. And it's my understanding that's going to, there's already the standard instruction. That's an add-on to the standard.
It's just a matter of where y'all want it. So I will add this to the red line to be sent out this afternoon. Ms. Boone, I want to have a couple other conversations with you, ma'am. Again, I don't want to know specifics of anything that you or your attorneys have discussed, just whether or not you've had those discussions. Did you hear the court read the proposed additional language to the jury instruction about your statements?
Just now?
Yes, ma'am.
Could you please read it one more time?
I can. So just to give you some background, ma'am, there's a form instruction. It's 3.9b, and it talks about how the jury is to consider your statements that were read to them and provided in evidence through the course of the trial. And that they're to consider the voluntariness of those statements and whether they were coerced. The state is seeking to add the following language to that instruction. Law enforcement is not legally required to ask a suspect whether he or she wants to talk to law enforcement after Miranda warnings are read to a suspect. This is, however, one of the factors you may consider whether the defendant's statements were voluntarily made. Do you understand that portion of the instruction?
Yes.
Do you have any questions about it?
No.
Okay. Have you had conversations with your attorneys about the proposed additional language that I just read to you?
Not yet.
Okay. Let's go ahead and have those conversations tonight when you all break, and we can go over this tomorrow when we have the charging conference. But I'll go ahead and add it to the red line for the purposes of our discussion tomorrow.
Thank you, Judge.
Okay. Anything else, state, we need to address?
Thank you.
Defense, anything else?
No, sir.
Okay, let's go ahead and bring our panel back in, and we'll tell them we'll commence tomorrow with additional evidence and testimony at 9 a.m.
Fast forward.
Again, could you just raise those hands? Come to the jury 9 a.m. tomorrow morning. We'll continue with evidence. I beg your forgiveness as you investigate shooter, cell phone, related to this case, or in the courthouse trial, during the trial. Jurors must, your fellow jurors, make comments to, just as you must not talk about this case face to face. You must not, do not send, do not discuss this case. Site, chat room, in this matter, and we'll see you tomorrow morning at 9 a.m.
To make sure there's nothing else here. Yeah, I think we're done. All right. I'm going to switch screens. Part of me wants to apologize for getting mad and yelling, but I kind of think you feel the same way. So, looks like the defense is going to rest pretty soon, sooner than I thought. Then we're going to hear the rebuttal, and those body cams are coming in. Okay, Tracy's asking, did the state impeach the doc before? Are you talking about, I'm not sure what you're talking about. Are you talking about a doctor? I'm not sure what you're referring to. I'm sorry. Somebody's going to have to clarify. Criminal Minds. How do you think the jury thought about the testimonies today? I don't know. I know what I thought. And I think that you guys are a better judge of what the jury is likely to think. Because they're not accustomed to sitting around in court, right? Whereas I am. So I'm going to perceive things differently. So I'm actually interested in what you guys think the jury is going to think. So can they call Brian Boone? Yeah. I hope they do. I hope they bring in how Sarah was violent towards him. I really want that in there. Yes, that expert, I'm disappointed. I was disappointed in that. I watched it when she went from being just telling, giving the expertise, giving the information to becoming an advocate. And she lost me there. So you're saying the blonde one with the glasses, Tracy? Oh, so you're asking if he impeached her? I don't think he impeached her, but he certainly challenged her for sure. And her demeanor changed quite a bit. She wasn't so friendly and confident. Her volume of her speech went down. Yes, the ring. Sarah wanted his ring back. Squid is saying, I still think the suitcase videos seal Sarah's fate. Thank you, Jane. I'm just, I can't wrap my head around how you could see, even as an expert, see that video and not recognize the vengeance that is so clearly there. And how when somebody tells you they have no memory of things, why you don't delve further into that. Were there tests done or even physical exams done to explain the lack of memory? So that was something. That expert, though, will never do that again. She was so embarrassed today on the stand. The next case she has, those areas that they got her on, she won't do that again. Froki says, yeah, too bad for Sarah's next victim. It's unfortunate. I mean, just... I almost went to like a philosophical thing, but I think I'm not going to. Cool Tina says, I don't think the defense can overcome the video. I hope you're right. I looked on Twitter last night just out of curiosity, and I noticed a lot of people really feeling sorry for Sarah, really saying, oh boy, he was terrible. You know what? Even if he was terrible, it doesn't justify what she did to him. Just if you don't like the victim, if you can't stand them, it still doesn't justify what she did to him. Mad Mystic says, I legit thought she was going to cry. You mean the witness? I didn't think that. Criminal Mind says, Grandma Pearl being on the stand was so heartbreaking for me. Yeah. Somebody's asking, what happens if the trial isn't over, but you've reached a decision? After the video, I would vote guilty. Do you have to tell the judge? You're not supposed to reach a decision. And this is one reason, by the way, why they tell the jurors they can't be talking about it even with each other while the trial is going on. They have to wait. Patty's asking, Lori, do you think she can actually beat this thing? I'm getting really worried. To me, this is so open and shut. To me, this is so obvious and solid. But I have all the information and I think differently. So I don't know, right? It depends on, you can get jurors, you can get a group who are very staunch and don't believe anything. You can get people with, they claim to be so open-minded, their flipping brains are falling out. I mean, who knows what you're going to get? Honestly, you guys are actually a better judge of that than I am. So, so my opinion is probably worth less than yours on that issue of what the jury's going to think. Ruth is saying 99% of us following this case know she's guilty. The jurors, I'm not sure. And that's the other thing. There's a whole lot that we've seen that the jurors never saw. So that is one thing to take into account. Although the jurors are seeing things back to back to back. Ashes is saying Mrs. Walker couldn't hear the judge and attorneys very well, but she could hear Sarah Boone's dogs barking 5 apartments away. Oh, that's a good point. That's a good point. I didn't think of that. So Carolina thinks Sarah's not going to walk. Oh, Paige, you're saying you saw a headline that was very clickbait? Yeah. For the Love of Justice says we have to hear closings and the rebuttal. It's not over yet. Yep. Yep, we're not done. Rita is pointing out that the jury is sitting inside the courtroom and has a different experience. Yes, it really is different when you're right there. Lisa's saying they will call her to the stand to explain that damning video. Call who to the stand? Sarah was already on the stand. And she's already been cross-examined. Feline Frenzy saying, I hope they show the video where she skips out the door. The one where she was snarky to the cop about Jesus. Yeah, that was funny. Yeah, the body cams will paint Sarah for who she is. And I like that the jury got to see her behavior in the interrogations, and they'll see her behavior elsewhere too, so that they see that she's not this sweet little thing, almost grandmotherly like, who is sitting in front of them in court in her nice tailored suit. Matcha, can you talk about my YouTube channel in class? Sure, you can talk about whatever you want. I hope you're nice. I will also talk about your book if that's okay. And my book is just fiction. So, yeah, sure. Of course. That's awesome. Yeah, they were arguing at the end. That issue was about him breaking the no contact order. But, you know, she wanted him to. That's not an excuse to break a no contact order. Look, if you've got a no contact order and that other person says, no, it's okay, I won't tell anybody, I really need you, I really want you here, you got a court order, you say, sorry, honey. Actually, you can't even say, sorry, honey. You can't say anything because you can't have any contact. You could even call the cops and say, listen, she's trying to get me to break this no contact order. I want her to leave me alone. Call your lawyer, but have no contact. Don't breach. Oh, thank you, Tracy. So Criminal Minds is asking, do you think Mr. J purposely allowed the no contact order in so he can also show those body cam videos? No, I don't think that. I think the issue itself was already brought up, and what Owens is doing is just trying to make it more official and just kind of pile on and make it, I mean, it just bolsters his side. So it's not like the issue wasn't already in. Mr. J didn't want to engage in like this big flippin' thing because some employee now is going to have to like be dragged into this after work and work overtime for this stupid. It's stupid. And he can overcome it with the body cam. So he just said, fine, like, fine. You know, he's picking his battles. Personally, I didn't want him to concede, but you do have to pick your battles. And he's a nice guy, right? Sarah and her team don't give a rip, or so it seems. Baby girl, it seems to me that Owens and his team were a little bit more prepared than they let on. Yes. Yes, of course. I told you it was an act. It's all a big game. In those body cam videos, George was so compliant and did everything the officers asked. Captain Katie thinks body cams will shut her poor me down. I don't know. I think that she thinks that everything will be perceived the way she wants to she wants it perceived, right? So I don't. Jane is saying Owens wants to extend the trial. I don't think so. I don't think so. So okay. So I know people are kind of crapping on the judge. There's only so much he can do. The judge must follow the law. That's it. He must follow the law. And if the case law says he has to do something, then he has to do that. Right? He can't just say, yeah, I don't believe you, or I think you're full of crap, or I don't want to do this. He can't do that. So, oh yeah. So people are talking, let's talk about self-care. Tonight, I am having dinner with family members, I hope. I hope it's still on. And some people are going for a walk. Someone said they're cleaning their house. Makes you feel better, right? What are you doing? You need a laugh? You need to listen to something beautiful? Nobody cares about the self-care. You're still mad about Sarah Boone. Okay. Criminal Minds is going to read a book. Brian did testify very early in the trial. During the state's case, Brian is not going to be called by the defense. Oh, Jeannie, you're on the treadmill now? I wonder if I have a rowing machine here. I wonder, I have a bike too. I wonder if I could like stream while I was doing that. I don't think it would work. Oh, Penlu's got a thesis to go back to writing. Ugh. Yes, have dinner, cool Tina. Somebody's cooking a pizza. Yep. Jetty B saying tomorrow state will show George's character. I think. I hope so. I hope so. All right, guys. I thank you so much for joining me. This chat is fabulous. You're bright. You're funny. You're patient. Really enjoy having you. I will see you tomorrow morning at 9 a.m. Trust your gut. And I'll see you later.